Q1. Define and explain administrative law. Discuss its nature and scope. Ans. It is difficult to evolve a scientific, precise and satisfactory definition of administrative law. Many jurists have made attempts to define it, but none of the definitions has completely demarcated the nature, scope and content of administrative law. The main object of this law is to protect individual rights. Administrative law is a branch of public law, which deals with the structure, powers and functions of the organs of administration, the limits of their powers, and the methods by which their powers are controlled, including the legal remedies available against them. Professor Jennings defines administrative law as the law relating to administration. It determines the organization, powers and duties of administrative authorities. H.L.A. Hart defines broadly conceived, administrative law includes law that is made as well as the law that controls the administrative authorities of the government. According to Wade, administrative law is the law relating to the control of governmental power. According to him, the primary object of administrative law is to keep powers of the government within their legal bounds so as to protect the citizens against their abuse. According to Casey Davis, administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. Garner also adopts the American approach advocated by Casey Davis. According to him, administrative law may be described as those rules which are recognized by the courts as law and which relate to and regulate the administration of government. Dicey has defined administrative law as, it is that portion of a nation's legal system which determines the legal status and liabilities of all state officials, and secondly, defines the rights and liabilities of private individuals in their dealings with public officials, and thirdly, specifies the procedure by which those rights and liabilities are enforced. This definition is narrow and restrictive insofar as it does not take into consideration many aspects of administrative law, such as public corporations, etc. His definition is mainly concerned with one aspect of administrative law, namely judicial control of public officials. So from above discussion it can be said that administrative law deals with structure, powers and functions of different administrative authorities and procedure to be followed by them in exercising powers and discharging duties so as to protect rights of any aggrieved person who has been affected by action of such authorities. Administrative law deals with the organization and powers of administrative authorities. The emphasis on the organization is only to the extent that it is necessary to understand the powers, characteristics of action, procedure for the exercise of those powers, and the control mechanism provided therein. In simple words, administrative law is the science of powers of administrative authorities. The nature of their powers can be studied under three heads. 1. Legislative or rulemaking. 2. Judicial or adjudicative. 3. Purely executive. The scope of administrative law in India is very much similar to that of United States. With the growth of the powers of administrative authorities, the question as to how to control these powers became very important. Administrative law deals with the powers of the administrative authorities, the manner in which the powers are exercised, and the remedies which are available to the aggrieved persons when these authorities abuse those powers. The key function of administrative law is to find the ways in which the administration could be kept within limits so that discretionary power may not become arbitrary powers. The task of administrative law is to reconcile, in the field of administrative action, democratic safeguard and standards of fair play with the effective conduct of government. As has been rightly observed by Lord Denning, properly exercised, the new powers of the executive lead to the welfare state, but abused they lead to the totalitarian state. The main object of the study of administrative law is to unravel the way in which these administrative authorities could be kept within their limits so that the discretionary powers may not be turned into arbitrary powers. Q2. Discuss historical background of administrative law and reasons for its growth. Ans. Historical background of administrative law in England. By and large, the existence of administrative law as a separate branch of law was not accepted until the advent of the 20th century. In 1885, Dicey in his famous thesis on rule of law observed that there was no administrative law in England. In 1914, however, Dicey changed his views. In his famous book Law and the Constitution, he admitted that during the last 30 years, due to increase of duties and authority of English officials, some elements of drought had entered into the law of England. Administrative law was in existence in India even in ancient times. The kings observed the rule of dharma and administrators, and nobody claimed any exemption from it. With the establishment of East India Company and the advent of the British rule in India, the powers of the government had increased. Many acts, statutes, and the British government, regulating public safety, health, morality, transport, and labor relations, passed legislations. Since independence, the activities and the functions of the government have further increased. The philosophy of a welfare state has been specifically embodied in the Constitution of India. The Constitution of India, which clearly mentions the welfare aspect of the state, and provides for an elaborate system of judicial control under Articles 32, 226, and 227 does accord recognition to the growing importance of this subject. The Constitution also envisages tribunals, public sector, and government liability, which are important aspects of administrative law. The Constitution of India visualizes a profound social transformation through law, and administrative law must play a very significant role in channeling the state effort so as to make it consistent with the democratic values built into it. The following factors are responsible for the rapid growth and development of administrative law. 1. There is a radical change in the philosophy as to the role played by the state. The negative policy of maintaining law and order and of laissez-faire is given up. The state has not confined its scope to the traditional and minimum functions of defense and has adopted the positive policy, and as a welfare state has undertaken to perform varied function. 2. The judicial system proved inadequate to decide and settle all types of disputes. 3. The legislative process was also inadequate. It had no time and technique to deal with all the details. 4. There is scope for experiments in administrative process. Here a rule can be made, tried for some time, and if it is found defective, it can be altered or modified within a short period. 5. The administrative authorities can avoid technicalities. Administrative law represents functional rather than a theoretical and legalistic approach. 6. Administrative authorities can take preventive measures. In many cases, these preventive actions may prove to be more effective and useful than punishing a person after he has committed a breach of any provision of law. 7. Administrative authorities can take effective steps for enforcement of the aforesaid preventive measures, e.g. suspension, revocation and cancellation of licenses, destruction of contaminated articles, etc., which are not generally available through regular courts of law. Q3. Distinguish between constitutional law and administrative law. Or, administrative law is part of constitutional law. It has become an independent branch of study only recently. Discuss. Ans. Constitutional law and administrative law. Sometimes, a question is asked as to whether there be any distinction between constitutional law and administrative law. Till recently, the subject of administrative law was dealt with and discussed in the books of constitutional law, and no separate and independent treatment was given to it. In many definitions of administrative law, it was included in constitutional law. Though in essence constitutional law does not differ from administrative law inasmuch as both are concerned with functions of the government and both are a part of public law in the modern state and the source of both are the same, yet there is a distinction between the two. Professor Wade writes, with the exercise of governmental power, administrative law is itself a part of constitutional law. It has now become independent branch of study. Professor Dicey repudiated its existence in United Kingdom and his view continued to occupy the minds of thinking persons till the advent of the Report of Committee on Ministers. He misunderstood droit administrative, which he identified with administrative law. According to him, since there was no dual system of judiciary in Great Britain, there is nothing like the term administrative law in England. The views of Austin, to whom constitutional law merely determined what persons or classes of persons bore the sovereign powers, while administrative law determined the ends and modes to and in which sovereign powers were exercised, are not complete in full sense, because he dealt constitutional law in very narrow sense. In this regard, Maitland said, I think we catch his idea if we say that while constitutional law deals with structure, administrative law deals with functions. Thus, according to the view of these writers, administrative law and constitutional law both deal with the same subject. Although there is much similarity in the subject matter of the two laws as the definition of administrative law by Jennings clearly indicates, yet the tremendous growth in the scope of administrative law has separated it from constitutional law. In India, administrative law has not grown up fully. It is in its infancy. Before 1947, our country was a police state. With the advent of independence, a conscious effort started towards the achievement of a welfare state. There are several principles which are derived from the constitutional law, and they constitute the fundamental basis of administrative law. In fact, among the various sources of administrative law, constitution stands foremost besides the statutes, statutory instruments, and precedents. Our constitution itself envisages a few administrative bodies mainly from the point of view of interstate cooperation and coordination and to solve interstate problems. Examples are the Interstate Council, the Finance Commission, Union Public Service Commission, and the Election Commission. Besides this, we have several provisions in the Constitution relating to control on the administrative powers. The inevitable and speedier growth of powers of the administration under the garb of socialization have resulted in outstanding legal development of the 20th century taking its force from constitutional law. Administrative law is very much related to constitutional law. It owes much to constitutional law, in spite of the fact that the former has developed as an independent branch of study. In many ways, constitutional law is the determining factor of administrative law. Q4. What does the phrase rule of law signify? How has it affected the growth and development of administrative law? Ans. Rule of law, it simply means that the law rules. Even in most autocratic form of government, there is some law which regulates as to how power of government is to be exercised. One of the basic principles of the English Constitution of USA is the rule of law. This doctrine is accepted in the Constitution of India. The entire basis of administrative law is the doctrine of the rule of law. According to Dicey, the rule of law is one of the fundamental principles of the English legal system. In his book, he attributed the following three meanings to the said doctrine. I. Supremacy of law. 2. Equality before law, and 3. Predominance of legal spirit. I. Supremacy of law. Explaining the first principle, Dicey states that rule of law means the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power or wide discretionary power. It excludes the existence of arbitrariness of prerogative or even wide discretionary authority on the part of the government. 2. Equality before law. Secondly, it means equality before the law or equal subjection of all classes to the ordinary law of the land administered by the ordinary law courts. Everyone, whatever his position, right from a state minister to a policeman, is governed by ordinary law of the land and personally liable for anything done by him contrary to that law, and is subject to the jurisdiction of the ordinary courts of justice, civil or criminal. On this point Dicey distinguished droit administrative from rule of law. He criticized the system of droit administrative in France, where there were separate administrative tribunals for deciding cases between the government and the citizen. On the basis of above analysis, he said that in England administrative law does not exist. 3. Predominance of legal spirit. Thirdly, rule of law may be used as formula for expressing the fact that with us the law of the Constitution are not the source but the consequences of the rights of individuals as defined and enforced by the courts. According to Dicey, administrative law is based on two ideas which are repugnant to the spirit of rule of law, viz. 1. That the government and its servants possess special rights, privileges, and prerogatives as against private citizens. An individual in his dealings with the state does not stand on the same footing as that on which he stands in dealings with his neighbor. 2. That government and its officials should be independent of and free from the jurisdiction of ordinary courts. Dicey states that in many countries rights such as right to personal liberty, freedom from arrest, freedom to hold public meetings are guaranteed by a written constitution. Those rights are the result of judicial decision. Thus, Dicey emphasized the role of the courts of law as guarantors of liberty and suggested that the rights would be secured more adequately if they were enforceable in the courts of law than by mere declaration of those rights in a document. According to him, mere incorporation or inclusion of certain rights in the written constitution is of little value in the absence of effective remedies of protection and enforcement. Dicey's thesis had its own advantages and merits. The doctrine of rule of law proved to be an effective instrument in confining the administrative authorities within their limits. It served as a kind of touchstone to judge and test administrative actions. The doctrine of the rule of law expounded by Dicey was never fully accepted in England even in his days. In 1885 there existed a long list of statutes which permitted the exercise of discretionary powers which could not be called in question by courts, and the Crown enjoyed the immunity under the maxim, "The King can do no wrong." The shortcoming of Dicey's thesis was that he not only excluded arbitrary powers, but also insisted that the administrative authorities should not be given wide discretionary powers, as according to him, wherever there is discretion, there is room for arbitrariness. Thus, Dicey failed to distinguish arbitrary power from discretionary power. Though arbitrary power is inconsistent with the concept of rule of law, discretionary power is not, if it is properly exercised. The modern welfare state cannot work properly without exercising discretionary power. Q5. Explain modern concept of rule of law. Ans. The modern concept of rule of law is fairly wide and, therefore, sets an ideal for any government to achieve. The rule of law implies that the functions of government in a free society should be so exercised as to create conditions, social, political, economical, educational, and cultural, in which the dignity of man as an individual is upheld. Rule of law means not only the adequate safeguards against abuse of power, but effective government capable of maintaining law and order. Though the concept of rule of law has all the merits, the only negative side of the concept is that respect for law degenerates into legalism, which from its very rigidity works injury to the nation. Dicey's concept of rule of law was not accepted fully even in 1885 when he formulated it. Today, Dicey's theory of rule of law cannot be accepted in its totality. Davis gives 7 principal meanings of the term rule of law. 1. Law and order. 2. Fixed rules. 3. Elimination of discretion. 4. Due process of law or fairness. 5. Natural law or observance of the principles of natural justice. 6. Preference for judges and ordinary courts of law to executive authorities and administrative tribunals, and 7. Judicial review of administrative action. Rule of law under Constitution of India. Dicey's rule of law has been adopted and incorporated in the Constitution of India. The preamble itself enunciates the ideals of justice, liberty and equality. In Chapter 3 of the Constitution, these concepts are enshrined as fundamental rights and are made enforceable. The Constitution is supreme and all the 3 organs of the government, viz. Legislature, Executive and Judiciary, are subordinate to and have to act in accordance with it. The principle of judicial review is embodied in the Constitution. If the executive or the government abuses the power vested in it, or if the action is nullified, the same can be quashed by the ordinary courts of law. All rules, regulations, ordinances, bylaws, notifications, customs and usage are laws within the meaning of Article 13 of the Constitution, and if they are inconsistent with or contrary to any of the provisions thereof, they can be declared as ultra vires by the Supreme Court and by high courts. No person shall be deprived of his life or personal liberty except according to procedure established by law. The executive and the legislative powers of the states and the union have to be exercised in accordance with the provisions of the Constitution. The government and the public officials are not above the law. The maxim, "the king can do no wrong," does not apply in India. There is equality before the law and equal protection of laws. In the case of Director of Rationing and Distribution v. The Corporation of Calcutta, 1961, 1 SCR 158 is equal to AIR 1960 SC 1355, 1 J, stated that in our country the rule of law prevails and our Constitution has guaranteed it by the provisions contained in Part 3 thereof as well as other provisions in other parts. In Bishan Das v. The State of Punjab, 1962, 2 SCR 69 is equal to AIR 1961 SC 1570, S. K. Das J. Speaking for the Constitution Bench of Supreme Court deprecated action taken by the state and its officers on the ground that it was destructive of the basic principles of the rule of law. In G. Sadanandan v. State of Kerala 1966 to 3 SCR 590 is equal to AIR 1966 SC 1925, Gajendra Datkar C. J. Speaking for the Constitution Bench observed that the paramount requirement of the Constitution was that even during emergency the freedom of Indian citizens would not be taken away without the existence of justifying necessity specified by the Defence of India rules. Similarly in S. G. Jasinghani v. Union of India, 1967, to SCR 703 is equal to AIR 1967 SC 1427, Ramaswamy J. Speaking for the Constitution Bench of Supreme Court observed as under. In this context it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law upon which our whole constitutional system is based. In a system governed by rule of law, discretion, when conferred upon executive authorities, must be confined within clearly defined limits. The rule of law from this point of view means that decisions should be made by the application of known principles and rules and, in general, such decisions should be predictable and the citizen should know where he is. If a decision is taken without any principle or without any rule, it is unpredictable, and such a decision is the antithesis of a decision taken in accordance with the rule of law. See Dicey Law of the Constitution 10th edition, Introduction X. Law has reached its finest moments, stated Douglas J. in United States v. Wunderlich, 1951, 340 to US 98 when it has freed man from the unlimited discretion of some ruler. Where discretion is absolute, man has always suffered. It is in this sense that the rule of law may be said to be sworn enemy of caprice. Discretion, as Lord Mansfield stated it in classic terms, in the case of John Wilkes, 1770, 4/2528 at p. 2539, means sound discretion guided by lay. It must be governed by rule, not by humor. It must not be arbitrary, vague and fanciful. Attribute of the rule of law has been specially highlighted in the decision of Apex Court in the case of State of Madhya Pradesh v. Thakur Bharat Singh, 1967, to SCR 454, AIR 1967 SC 1170. In that case, the state government made an order under Section 3 of the Madhya Pradesh Public Security Act, 1959, directing that the respondent, I, shall not be in any place in Raipur district, 2, shall immediately proceed to and reside in a named town, and 3, shall report daily to a police station in that town. The respondent challenged the order by a writ petition under Articles 226 and 227 of the Constitution on the ground, inter alia, that Section 3 infringed the fundamental rights guaranteed under Article 19 of the Constitution. The court declared clauses 2 and 3 of the order invalid on the ground that clauses B and C of Section 3(1) of the Madhya Pradesh Public Security Act on which they were based contravened Article 19. On appeal, Supreme Court held that Section 8(1)(b) violated Article 19 and as it was a pre-emergency enactment, it must be deemed to be void when enacted. Section 3(1)(b) was further held not to have revived as a result of the proclamation of emergency by the President. It was observed, all executive action which operates to the prejudice of any person must have the authority of law to support it. 1. The sovereignty of the people with limited government authority, i.e., the government must be conducted in accordance with the will of the majority of the people. The people govern themselves through their representatives, whereas the official agencies of the executive government possess only such powers as have been conferred upon them by the people. 2. There is distribution of powers between the three organs of the state: legislative, executive, and judicial, each organ having some check, direct or indirect, on the other. And 3. The rule of law, which includes judicial review of arbitrary executive actions. As pointed out by Dicey in his Introduction to the Study of the Law of the Constitution, 10th ed. At p. 200, to the expression, rule of law has three meanings, or may be regarded from three different points of view. It means, in the first place, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power, and excludes the existence of arbitrariness, of prerogative, or even of wide discretionary authority on the part of the government. At p. 188, Dicey points out, in almost every continental community, the executive exercises far wider discretionary authority in the matter of arrest, of temporary imprisonment, of expulsion from its territory, and the like, than is either legally claimed or in fact exerted by the government in England. And a study of European politics now and again reminds English readers that wherever there is discretion there is room for arbitrariness, and that in a republic no less than under a monarchy, discretionary authority on the part of the government must mean insecurity for legal freedom on the part of its subjects. We have adopted under our constitution not the continental system but the British system, under which the rule of law prevails. In the case of Srimati Indira Nehru Gandhi v. Shri Raj Narayan, 1975, sub SCC 1, AIR 1975 SC 20-99, Supreme Court laid stress on the rule of law in our constitutional scheme. These authorities clearly highlight the principle that executive authorities cannot, under the rule of law, take any action to the prejudice of an individual unless such action is authorized by law. A fortiori it would follow that under the rule of law it is not permissible to deprive a person of his life or personal liberty without the authority of law. Q6. What do you understand by doctrine of separation of powers? Discuss its importance in relation to administrative law. Ans. Doctrine of separation of power. The doctrine of separation of powers emphasizes the mutual exclusiveness of three organs of government, viz. legislature, executive, and the judiciary. Doctrine of separation is based on following principles. A. That the same set of persons should not form part of more than one of the three organs of government. B. That one organ of government should not control or interfere with the exercise of functions of another organ. Example, judiciary should be independent of the executive. C. That one organ of government should not exercise the functions of the other two departments. Montesquieu. The doctrine of separation of powers was first formulated by the French jurist Montesquieu. His statement of doctrine has been thus interpreted as if the executive and the legislative are the same person or body of persons, there would be a danger of the legislative enacting oppressive laws which the executive will administer to attain its own ends. Further, he said that if judicial and executive powers were concentrated in one person or a body of persons, then there would be no objectivity of law. And to concentrate the powers of all the three organs in one person or body of persons would mean to create virtual despot of the state. According to Wade and Phillips, separation of powers may mean three different things. I. That the same person should not form part of more than one of the three organs of government, e.g. the ministers should not sit in parliament. 2. That one organ of the government should not control or interfere with the exercise of its function by another organ, e.g. the judiciary should be independent of the executive, or that ministers should not be responsible to parliament, and 3. That one organ of the government should not exercise the functions of another, e.g. the ministers should not have legislative powers. Q7. Discuss the doctrine of separation of powers in India. Ans. In India, the doctrine cannot claim any historical background. The doctrine in its absolute rigidity is not inferable from the provisions of the Constitution. However, Article 50 provides for the separation of the judiciary from the executive. As a general practice, the executive has been entrusted with the legislative and judicial powers. We have adopted parliamentary form of government based on the pattern of British system. The President exercises all executive powers, but under Article 74 there is to be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. But like the American President, he is the Supreme Commander of the Armed Forces, Air Force, and the Navy. He can declare war himself, send armies abroad without consulting the legislature. This has been contained in Article 53 of the Constitution, but Clause 2 of the said article provides that law shall regulate the exercise of such powers. Furthermore, the Parliament can confer the power on any other authority. Article 53 of the Constitution vests all executive powers in the President. The Constitution does not vest the powers with the Indian President in the same manner as the Constitution of the US vests the powers in the President thereof. The Constitution has recognized the need for the separation of the judiciary from the executive as a directive to state policy in Part 4. In certain states, this step has been taken on experimental basis. Besides, a series of checks and balances are patent in Constitution, and they can be summarized thus. I. The Indian legislative bodies are not sovereign. Their rights of legislation are regulated. 2. The various lists, I, 2, and 3, of the Constitution. 3. The provision of Part 3. 4. The possibility of judicial veto on legislation, and the requirement that the President and the Council of Ministers have to act in accordance with the Constitution, and the provision for impeachment of the President if he fails to act in accordance with the provisions of the Constitution. Furthermore, under Article 265 of the Constitution, the executive powers in any state are to be exercised in such a way as to ensure compliance with the Constitution. So far as the judiciary is concerned, the Constitution provides for dismissal of a judge on a motion in that behalf passed under Article 174. So it will be noticed that these are checks and balances on various agencies of the state, which operate under the various provisions of the Constitution. Therefore, it can be said that the Indian Constitution believes in checks and balances and not on any rigid separation of powers. It was rightly laid down by Mukherjee, J. in Ram Javaya v. State of Punjab, AIR 1955 SC 549, that the Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity. Justice Das, in the case of Ram Krishna Dalmia v. Justice Tendulkar, 1959 SCR 229, has said the Constitution does not express the existence of the separation of powers, and the doctrine does not form an essential basis or foundation stone of the constitutional framework as it does in the USA. In Kartar Singh v. State of Punjab AIR 1995 SC 1726 K. Ramaswamy, J. stated, it is the basic postulate under the Indian Constitution that the legal sovereign power has been distributed between the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set down by the Constitution. In Golak Nath v. State of Punjab AIR 1967 SC 1643 Subbarao, CJ observed, the Constitution brings into existence different constitutional entities, namely the Union, the states, and the Union territories. It creates three major instruments of power, namely the legislature, the executive, and the judiciary. It demarcates their jurisdiction minutely and expects them to exercise their respective powers without overstepping their limits. They should function within the spheres allotted to them. So, if we study the constitutional provisions carefully, it is clear that the doctrine of separation of powers has not been accepted in India in its strict sense. Q8. So the judicial function merges into legislative and legislative into administrative. Discuss. Ans. As observed earlier, there are three organs of government: 1. Legislature, 2. Executive, and 3. Judiciary. These three organs essentially perform three classes of governmental functions: 1. Legislative, 2. Executive or administrative, and 3. Judicial. The function of the legislature is to enact the law, the executive is to administer the law, and the judiciary is to interpret the law and to declare what the law is. But as observed by the Supreme Court in Jayantilal Amritlal v. F. N. Rana, AIR 1964 SC 648, 655, 1964, 5 SCR to 94, it cannot be assumed that the legislative function are exclusively performed by the legislature, executive function by the executive, and judicial function by the judiciary. Today, the executive performs variegated function, viz., to investigate, to prosecute, to prepare and to adopt schemes, to issue and cancel licenses, etc., administrative, to make rules, regulations and bylaws, to fix prices, etc., legislative, to adjudicate on disputes, to impose fine and penalty, etc., judicial. Schwartz rightly states that rulemaking, quasi-legislative, and adjudication, quasi-judicial, have become the chief weapons in the administrative armory. Quasi is a smooth cover, which we draw over our confusion as we might use a counterpane to conceal a disordered bed. A question which arises for our consideration is whether the functions performed by the executive authorities are purely administrative, quasi-judicial or quasi-legislative in character. The answer is very difficult, as there is no precise, perfect and scientific test to distinguish these functions from one another. The courts have not been able to formulate any definite test for the purpose of making such classification. Yet, such classification is essential and inevitable as many consequences flow from it, e.g., if the executive authority exercises a judicial or quasi-judicial function, it must follow the principles of natural justice and is amenable to the writ of certiorari or prohibition, but if it is an administrative, legislative or quasi-legislative function, this is not so. If the action of the executive authority is legislative in character, the requirement of publication, laying on the table, etc. should be complied with, but it is not necessary in the case of a pure administrative action. Again, if the function is administrative, delegation is permissible, but if it is judicial, it cannot be delegated. An exercise of legislative power may not be held invalid on the ground of unreasonableness. It is, therefore, necessary to determine what type of function the administrative authority performs. Q9. What is meant by administrative action? How do you distinguish the Administrative Act from Quasi-Judicial Act? Ans. Executive power is not defined in the Constitution. Article 73 relating to the Union of India and Article 163 relating to the state deal primarily with the extent of executive power. In Rai Sahib Ram Javaya Kapoor v. State of Punjab, 1955, to SCR 225, AIR 1955 SC 549, the then Chief Justice Mukherjee pointed out, Para 12 of AIR. It may not be possible to frame an exhaustive definition of what executive function means and implies. Ordinarily, the executive power connotes the residue of governmental functions that remain after legislative and judicial functions are taken away. In Indian Railway Construction Co. Limited v. Ajay Kumar, AIR 2003 SC 1843, it was observed that administrative action is stated to be referable to broad area of governmental activities in which the repositories of power may exercise every class of statutory function of executive, quasi-legislative and quasi-judicial nature. It is straight law that exercise of power, whether legislative or administrative, will be set aside if there is manifest error in the exercise of such power or the exercise of the power is manifestly arbitrary. The court will be slow to interfere in such matters relating to administrative functions unless decision is tainted by any vulnerability like illegality, irrationality, and procedural impropriety. Whether action falls within any of the categories has to be established. Mere assertion in that regard would not be sufficient. Thus, administrative functions are those functions which are neither legislative nor judicial in character. Generally, the following ingredients are present in administrative functions. 1. An administrative order is generally based on governmental policy or expediency. 2. In administrative decisions, there is no legal obligation to adopt a judicial approach to the questions to be decided, and the decisions are usually subjective rather than objective. 3. An administrative authority is not bound by the rules of evidence and procedure unless the relevant statute specifically imposes such an obligation. 4. Administrative functions may be delegated and subdelegated unless there is a specific bar. 5. While taking a decision, an administrative authority may not only consider the evidence adduced by the parties to the dispute, but may also use its discretion. 6. The prerogative writs of certiorari and prohibition are not always available against administrative actions. Distinction between administrative and quasi-judicial function in state of APV, S.M.K. Parsurma Gurukul, AIR 1973 SC 2237, it was observed that the test for determining whether a decision is an administrative one or quasi-judicial has been clearly specified in a number of decisions of this court. Essentially, they are three in number. 1. There must be a lease between the two parties. 2. The opinion should be formed on the objective satisfaction and should not depend upon the subjective satisfaction of the tribunal. And 3. There must be a duty to act judicially. As to what is a quasi-judicial as against an administrative or ministerial function, Lord Loreburn, LC in Board of Education v. Rice, 1911 AC 179 at p. 182, had stated, comparatively recent statutes have extended, if they have not originated, the practice of imposing upon departments or officers of state the duty of deciding or determining the questions of various kinds. In the present instance, as in many others, what comes for determination is sometimes a matter to be settled by discretion, involving no law. It will, I suppose, usually be of an administrative kind, but sometimes it will involve a matter of law as well as a matter of fact, or even depend upon a matter of law alone. In such cases, the Board of Education will have to ascertain the law and also to ascertain the facts. I do not add that in doing either they must act in good faith and fairly listen to both sides, for that is a duty lying upon every one who decides anything. But I do not think that they are bound to treat such a question as though it were a trial. They can obtain information in any way they think best, always giving a fair opportunity to those who are parties in the controversy for correcting or contradicting any relevant statement prejudicial to their view. Similar sentiments were also expressed by Lord Haldane in Local Government Board v. Arledge, 1915 AC 120 at p. 132. The Lord Chancellor there stated, when the duty of deciding an appeal is imposed, those whose duty it is to decide it must act judicially. They must deal with the question referred to them without bias, and they must give to each of the parties the opportunity of adequately presenting the case made. The decision must be come to in the spirit and with the sense of responsibility of a tribunal whose duty it is to mete out justice. The principles distinguishing a quasi-judicial function from one which is ministerial were more precisely set out in Province of Bombay v. Case Advani, 1950, 1 SCR 621, AIR L 950 SC to 22, wherein it was observed, 1. Where there is a lease, there is prima facie in the absence of anything in the statute to the contrary the duty of the authority to act judicially and the decision of the authority is a quasi-judicial act, and 2. Even if there is no lease inter partes and the contest between the party proposing to do the act and the subject opposing it, the final determination of the authority will yet be a quasi-judicial act provided the authority is required by the statute to act judicially. Hobieli Kanya CJ had observed that it is broadly stated that when a fact has to be determined by an objective test and when that decision affects rights of someone, the decision or act is quasi-judicial. This last statement overlooks the aspect that every decision of the executive generally is a decision of fact and in most cases affects the rights of someone or the other. Because an executive authority has to determine certain objective facts as a preliminary step in the discharge of an executive function, it does not follow that it must determine those facts judicially. When the executive authority has to form an opinion about an objective matter as a preliminary step to the exercise of a certain power conferred on it, the determination of the objective fact and the exercise of the power based thereon are alike matters of an administrative character and are not amenable to the writ of certiorari. These principles have since been acted upon by Apex Court in subsequent decisions such as Nagendra Nath Bora v. of Hills Division, 1958 SCR 1240, AIR 1958 SC 398, Radhesham Khare v. State of Madhya Pradesh, 1959 SCR 1440, AIR 1959 SC 107, Gullapalli Nageshwar Rao v. Andhra Pradesh State Road Transport Corporation, 1959 Sup. 1, SCR 319, AIR 1959 SC 308, and Shivji Nath Ubhai v. Union of India, 1960, to SCR 775, AIR 1960 SC 606. So following principles can be laid down regarding Quasi-Judicial Act. I. That if a statute empowers an authority, not being a court in the ordinary sense, to decide disputes arising out of a claim made by one party under the statute which claim is opposed by another party, and to determine the respective rights of the contesting parties who are opposed to each other. There is a lease and prima facie, and in the absence of anything in the statute to the contrary, it is the duty of the authority to act judicially, and the decision of the authority is a quasi-judicial act. And 2. That if a statutory authority has power to do any act which will prejudicially affect the subject, then, although there are not two parties apart from the authority proposing to do the act and the subject opposing it, the final determination of the authority will yet be a quasi-judicial act provided the authority is required by the statute to act judicially. In other words, while the presence of two parties besides the deciding authority will prima facie and in the absence of any other factor impose upon the authority the duty to act judicially, the absence of two such parties is not decisive in taking the act of the authority out of the category of quasi-judicial act if the authority is nevertheless required by the statute to act judicially. Quasi-judicial functions. Illustrations. The following functions are held to be quasi-judicial functions. A. Disciplinary proceedings against students. B. Dismissal of an employee on the ground of misconduct. C. Confiscation of goods under the Sea Customs Act, 1878. D. Cancellation, suspension, revocation or refusal to renew license or permit by licensing authority. E. Determination of citizenship. Administrative functions. Illustrations. The following functions are held to be administrative functions. A. An order of prevention is held to be administrative function. B. An order of acquisition or requisition of property. C. An order setting up a commission of inquiry. D. An order making or refusing to make a reference under the Industrial Disputes Act, 1947. E. An order granting sanction to prosecute a public servant. F. An order granting or refusing to grant permission of sale in favor of non-agriculturist under Tenancy Acts. Q. 10. Distinguish between judicial and quasi-judicial action. Ans. A quasi-judicial function differs from a purely judicial function in the following respects. I. A quasi-judicial authority has some of the trappings of a court, but not all of them. Nevertheless, there is an obligation to act judicially. 2. A lease inter partes is an essential characteristic of a judicial function, but this may not be true of a quasi-judicial function. 3. A court is bound by the rules of evidence and procedure while a quasi-judicial authority is not. 4. While precedents bind a court, a quasi-judicial authority is not. A court cannot be a judge in its own cause, except in contempt cases, while an administrative authority vested with quasi-judicial powers may be a party to the controversy but can still decide it. In Bharat Bank, Limited, Delhi v. Employees of the Bharat Bank, Limited, Delhi, AIR 1950 SC 188, Hobbieli Supreme Court relied upon following quotation. A true judicial decision presupposes an existing dispute between two or more parties, and then involves four requisites. 1. The presentation, not necessarily orally, of their case by the parties to the dispute. 2. If the dispute between them is a question of fact, the ascertainment of the last by means of evidence adduced by the parties to the dispute and often with the assistance of argument by or on behalf of the parties on the evidence. 3. If the dispute between them is a question of law, the submission of legal argument by the parties. And 4. A decision which disposes of the whole matter by a finding upon the facts in dispute and application of the law of the land to the facts so found. including where required ruling upon any disputed question of law. A quasi-judicial decision equally presupposes an existing dispute between two or more parties and involves 1 and 2 but does not necessarily involve 3 and never involves 4. The place of 4 is in fact taken by administrative sanction, the character of which is determined by the minister's free choice. Q11. What do you understand by administrative instructions or directions? Ans. Subject to the provisions of the Constitution, the executive power of the Union and the states extends to all matters in respect of which Parliament or state legislatures have power to make laws, Articles 72 and 162. The executive power includes both the determination of policy as well as carrying it into execution. Thus, the power to issue instructions or directions flows from the general executive power. Administrative instructions or directions may be specific or general and directory or mandatory. What kind of instructions it is depends generally on the provisions of the statute, which authorize the administrative agency to issue instructions. Instructions, which are not issued under any statutory power, are considered as directory, and hence are unenforceable, not having the force. In Raman and Raman v. State of Madras, AIR 1959 SC 694, the Supreme Court came to the conclusion that the administrative instructions, despite their issuance under Section 43 of the Motor Vehicles Act, 1939, do not have the force of law. However, in Jagjit Singh v. State of Punjab, 1978, to SCC 196, the Supreme Court made administrative instructions enforceable to get a scheduled caste candidate appointed in civil service. In Union of India v. Anglo-Afghan Agencies, AIR 1968 SC 778, an export scheme was declared by the Textile Commissioner for providing certain incentives to exporters of woolen goods. Relying on the representation in the scheme, petitioner exported sizable quantity of goods but was not granted import certificate. When this action was challenged, the court held that the scheme was enforceable. In this way, the law relating to administrative instructions or directions as regards their statutory status and enforceability is in highly nebulous state. The judicial approach in this respect has been residual and variegated. Q12. What is meant by delegated legislation? Discuss nature and scope of delegated legislation and reasons for its growth. Ans. Today, the bulk of the law which governs people come not from the legislature, but from the chambers of administrators. Delegated legislation, or administrative rulemaking, a quasi-legislative action, in simple terms refers to all lawmaking which takes place outside the legislature and is generally expressed as rules, regulations, orders, bylaws, directions, scheme, etc. In India, the term commonly employed is also subordinate legislation. It conveys the idea that the authority making the legislation is subordinate to the legislature. Delegated legislation is different from the executive legislation, where the executive may have lawmaking powers as vast and original as that of the legislature, e.g. ordinance-making power of president and governors. The simple meaning of the expression delegated legislation may be given as under. When the function of legislation is entrusted to an organ other than the legislature by the legislature itself, the legislation made by such organ is called delegated legislation. According to MP Jain, the term delegated legislation is used in two senses. It may mean A. Exercise by a subordinate agency of the legislative power delegated to it by the legislature, or B. The subsidiary rules themselves which are made by the subordinate authority in pursuance of the power conferred on it by the legislature. In its first application, it means that the authority making the legislation is subordinate to the legislature. an authority other than the legislature exercise of the powers delegated or conferred on them by the legislature. It exercises the legislative powers. This is also known as subordinate legislation, because the powers of the authority which makes it are limited by the statute which conferred the power, and consequently, it is valid only insofar as it keeps within those limits. In its second connotation, delegated legislation means and includes all rules, regulations, bylaws, order, etc. Reasons for growth of delegated legislation. Many factors are responsible for the rapid growth of delegated legislation in every modern democratic state. The traditional theory of laissez-faire has been given up by every state, and the old police state has now become a welfare state. Because of this radical change in the philosophy as to the role to be played by the state, its functions have increased. Consequently, delegated legislation has become essential and inevitable. The factors responsible for the growth of delegated legislation are: A. Pressure upon parliamentary time. As a result of the expanding horizons of state activity, the bulk of legislation is so great that it is not possible for the legislature to devote sufficient time to discuss all the matters in detail. Therefore, legislature formulates the general policy, the skeleton, and empowers the executive to fill in the details, thus giving flesh and blood to the skeleton so that it may live by issuing necessary rules, regulations, bylaws, etc. B. Technicality. Sometimes, the subject matter on which legislation is required is so technical in nature that the legislator, being himself a common man, cannot be expected to appreciate and legislate on the same, and the assistance of experts may be required. Members of Parliament may be the best politicians, but they are not experts to deal with highly technical matters, which are required to be handled by experts. Here the legislative power may be conferred on experts to deal with the technical problems. C. Flexibility. At the time of passing any legislative enactment, it is impossible to foresee all the contingencies, and some provision is required to be made for these unforeseen situations demanding exigent action. A legislative amendment is a slow and cumbersome process, but by the device of delegated legislation, the executive can meet the situation expeditiously. D. Experiment. The practice of delegated legislation enables the executive to experiment. This method permits rapid utilization of experience and implementation of necessary changes in application of the provisions in the light of such experience, e.g. in road traffic matters, an experiment may be conducted, and in the light of its application necessary changes could be made. E. Emergency. In times of emergency, quick action is required to be taken. The legislative process is not equipped to provide for urgent solution to meet the situations. Delegated legislation is the only convenient, indeed the only possible remedy. F. Complexity of modern administration. The complexity of modern administration and expansion of the function of the state to the economic and social sphere have rendered it necessary to resort to new forms of legislation and to give wide powers to various authorities on suitable occasion. In St. John's Teachers Training Institute V, Regional Director, National Council for Teacher Education EIA 2003 SC 1533, it was observed that the power to make subordinate legislation is derived from the Enabling Act, and it is fundamental that the delegate on whom such a power is conferred has to act within the limits of authority conferred by the Act. Rules cannot be made to supplant the provisions of the Enabling Act but to supplement it. What is permitted is the delegation of ancillary or subordinate legislative functions, or what is fictionally called a power to fill up details. The legislature may, after laying down the legislative policy, confer discretion on an administrative agency as to the execution of the policy, and leave it to the agency to work out the details within the framework of policy. The need for delegated legislation is that they are framed with care and minuteness when the statutory authority making the rule, after coming into force of the Act, is in a better position to adapt the Act to special circumstances. Delegated legislation permits utilization of experience and consultation with interests affected by the practical operation of statutes. Rules and regulations made by reason of the specific power conferred by the statute to make rules and regulations establish the pattern of conduct to be followed. Regulations are in aid of enforcement of the provisions of the statute. The process of legislation by departmental regulations saves time and is intended to deal with local variations, and the power to legislate by statutory instrument in the form of rules and regulations is conferred by Parliament. The main justification for delegated legislation is that the legislature being overburdened and the needs of the modern-day society being complex, it cannot possibly foresee every administrative difficulty that may arise after the statute has begun to operate. Delegated legislation fills those needs. In Julundur Rubber Goods Manufacturers Association, MSW, Union of India, Air 1970 SC 1589, it was observed that it is well established that essential legislative functions consist of the determination of the legislative policy and its formulation as a binding rule of conduct and cannot be delegated by the legislature. What can be delegated is the task of subordinate legislation necessary for implementing the purpose and objects of an enactment. Where legislative policy is enunciated with sufficient clearness or a standard is laid down, the courts will not interfere. It will depend on consideration of the provisions of a particular act, including its preamble as to the guidance which has been given and the legislative policy which has been laid down in the matter. In Arnold Rodericks v. State of Maharashtra AIR 1966 SC 1788, it was observed that delegated legislation is a well-known modern device. In view of the complexities of modern life, it is not possible for the legislature to find time to make all the detailed rules which are necessary to carry out the purposes of an enactment, so it delegates to an appropriate executive authority the power to make rules. But before doing so, the legislature itself enacts the law under which the power is delegated and lays down the essential policy of the Act and all such essential matters which require to be included in the Act itself. Having thus provided for all such essential matters in the enactment itself, the legislature leaves it to a subordinate authority, which may be some appropriate executive authority, to frame detailed rules to carry out the purposes of the Act. These rules are ancillary and subserve the purposes of the enactment. They cannot go against the provisions of the enactment and cannot in any manner make any change in the provision of the enactment, and are merely for the purpose of carrying out the essential policy which the legislature has laid down in the enactment itself. These rules are called delegated legislation, and it is important to remember that this delegated legislation cannot in any way change the provisions of the enactment itself and must only be resorted to for carrying out the purposes of the legislation itself. Such being the nature of delegated legislation, we have to see whether the impugned provisions of Section 3 are in accord with these principles. If they are not, and if the legislature has conferred powers on the state government beyond this, such conferment of power cannot be delegated legislation and is really an abdication of its power by the legislature and transfer of it to the executive. Q. 13. What are the forms of delegated legislation? Ans. Delegated legislation may take several forms. They may be normal or of exceptional type. They may be usual or unusual, positive or negative, Skelton or Henry VIII clause. Broadly speaking, delegated legislation may be classified on the following forms. 1. Colonial. The powers of self-government entrusted to the colonies and other dependencies of the Crown are subject to the control of the imperial legislature. The Parliament Westminster may repeal, alter, or supersede any colonial enactment, and such enactments constitute, accordingly, the first and most important species of subordinate legislation. It has been held, however, that for the purpose of the maxim delegates non-poets delegate, a colonial legislature is not a mere delegate of the imperial parliament and hence can delegate its legislative power to other bodies that in turn are dependent upon it. 2. Executive. The essential function of the executive is to conduct the administrative departments of the state, but it combines with the certain subordinate legislative powers which have been expressly delegated to it by Parliament, or certain to it by the common law statutes. For example, frequently entrusts to some department of the executive government the duty of supplementing the statutory provisions by the issue of more detailed regulations bearing out the same matter. 3. Judicial. In the same way, the judicature possesses certain delegated legislative powers. The superior courts have the power of making rules for the regulation of their own procedure. This is judicial legislation in the true sense of the term, differing in this respect from the so-called legislative actions of the courts in creating new law by way of precedent. 4. Municipal. Municipal authorities are entrusted by the law with limited and subordinate powers of establishing special law for the districts under their control. The enactments so authorized are termed bylaws, and this form of legislation may be distinguished as municipal. 5. Autonomous. All the kinds of legislation which we have hitherto considered proceed from itself, either in its supreme or in one or other of its many subordinate departments. But this is not necessarily limited to the state. It is accepted by the state as a sufficient legal ground for giving effect to those new principles in its courts of justice. The great bulk of enacted laws are promulgated by the state in its own person. But in exceptional cases it has been found possible to entrust this power to autonomous bodies. Q. 14. Distinguish between delegated legislation and conditional legislation. Ans. Delegated legislation and conditional legislation, distinction where the legislature lays down the principle of a particular statute and then leaves the following to the executive or to the delegate, it will be called conditional legislation. It includes the following. 1. The time when provision should be enforced. 2. The period during which it is to be implemented or suspended, and 3. The place where it should be applied. In delegated legislation, the delegate completes the legislation by supplying the details within the limits prescribed by the statute. In case of conditional legislation, the power of the legislation is exercised by the legislature conditionally, leaving it to the discretion of the external authority the time and manner of carrying the legislation into effect, as also the determination of the area to which it is to extend. In state of TNV, K. Subnadam AIR 1998 SC 344, it was observed that in the case of conditional legislation, the legislation is complete in itself, but its operation is made to depend on fulfillment of certain conditions, and what is delegated to an outside authority is the power to determine according to its own judgment whether or not those conditions are fulfilled. In case of delegated legislation proper, some portion of the legislative power of the legislature is delegated to the outside authority in that the legislature, though competent to perform both the essential and ancillary legislative functions, performs only the former and parts with the latter, i.e., the ancillary function of laying down details in favor of another for executing the policy of the statute enacted. The distinction between the two exists in this, that whereas conditional legislation contains no element of delegation of legislative power and is, therefore, not open to attack on the ground of excessive delegation, delegated legislation does confer some legislative power on some outside authority and is therefore open to attack on the ground of excessive delegation. In Hamdard Davakhana v. Union of India AIR 1960 SC 554, it was observed that the distinction between conditional legislation and delegated legislation is this, that in the former the delegate's power of that of determining when a legislative declared rule of conduct shall become effective, and the latter involves delegation of rule-making power which constitutionally may be exercised by the administrative agent. This means that the legislature, having laid down the broad principles of its policy in the legislation, can then leave the details to be supplied by the administrative authority. In other words, by delegated legislation, the delegate completes the legislation by supplying details within the limits prescribed by the statute, and in the case of conditional legislation, the power of legislation is exercised by the legislature conditionally, leaving to the discretion of an external authority the time and manner of carrying its legislation into effect, as also the determination of the area to which it is to extend. Thus, when the delegate is given the power of making rules and regulations in order to fill in the details to carry out and subserve the purposes of the legislation, the manner in which the requirements of the statute are to be met, and the rights therein created to be enjoyed, it is an exercise of delegated legislation. But when the legislation is complete in itself, and the legislature has itself made the law, and the only function left to the delegate is to apply the law to an area or to determine the time and manner of carrying it into effect, it is conditional legislation. Q. 15. State the permissible or constitutional limits to the delegation of legislative power by Indian Legislature. Explain the basis of those limits. Ans. Delegated legislation, as discussed above, means delegation of function of legislation to organs other than legislature by legislature itself, and is generally expressed as rules, regulations, bylaws, etc. Delegated legislation is well recognized by Constitution of India, as Article 13(3) defines the law as including any ordinance, order, bylaws, rule, etc. having force of law. There is nothing in Constitution prohibiting legislature to delegate. However, at the same time, it is well settled that essential and primary legislative functions must be performed by legislature itself and cannot be delegated to executive. There is no agreed formula with reference to which one can decide the permissible limits of delegation, or that when the law will be bad on account of excessive delegation. Thus, every case is decided in its special setting. The tendency on the part of the courts is to uphold the delegation, and it is only rarely that a statutory provision may be struck down on the ground of excessive delegation. Constitutional permissible limits on the delegated legislation. I. Essential legislative function. I. Laying the policy of the Act and enacting that policy into a binding rule of conduct cannot be delegated by the legislature. 2. While what constitutes an essential feature cannot be delineated in detail, it certainly can't include a change of policy. 3. After the legislature has exercised its essential legislative functions, it can delegate non-essentials, however numerous and significant they may be. 4. The delegated legislation must be consistent with the parent act and must not violate legislative policy and guidelines. Delegate cannot have more legislative powers than delegator. The delegated legislation, in order to be valid, must not be unreasonable and must not violate any procedural safeguards if provided in the parent act. 6. Subdelegation of legislative powers, in order to be valid, must be expressly authorized by the parent act. It will be useful to reproduce here a passage from Administrative Law by Wade and Forsythia, 8th edition 2000 at page 839. Administrative legislation is traditionally looked upon as a necessary evil, an unfortunate but inevitable infringement of the separation of powers. But in reality, it is no more difficult to justify it in theory than it is possible to do without it in practice. There is only a hazy borderline between legislation and administration, and the assumption that they are two fundamentally different forms of power is misleading. There are some obvious general differences. But the idea that a clean division can be made, as it can be more readily in the case of the judicial power, is a legacy from an older era of political theory. It is easy to see that legislative power is the power to lay down the law for people in general, whereas administrative power is the power to lay down the law for them or apply the law to them in some particular situation. The question whether any particular legislation suffers from excessive delegation has to be decided having regard to the subject matter, the scheme, the provisions of the statutes including its preamble and the facts and circumstances in the background of which the statute is enacted. See Registrar, Cooperative Societies v. K. Punjab Mu, AIR 1980 SC 350 and State of Nagaland v. Ratan Singh, AIR 1967 SC 212. It is also well settled that in considering the vires of subordinate legislation one should start with the presumption that it is intra vires, and if it is open to two constructions, one of which would make it valid and other invalid, the courts must adopt that construction which makes it valid, and the legislation can also be read down to avoid its being declared ultra vires. St. John's Teachers Training Institute v. Regional Director, National Council for Teacher Education AIR 2003 SC 1533, in Maharashtra SB, OS and HS Education v. Paritosh AIR 1984 SC 1543. It was observed that the question whether a particular piece of delegated legislation, whether a rule or regulation or other type of statutory instrument, is in excess of the power of subordinate legislation conferred on the delegate has to be determined with reference only to the specific provisions contained in the relevant statute conferring the power to make the rule, regulation, etc., and also the object and purpose of the Act as can be gathered from the various provisions of the enactment. It is exclusively within the province of the legislature and its delegate to determine, as a matter of policy, how the provisions of the statute can best be implemented and what measures, substantive as well as procedural, would have to be incorporated in the rules or regulations for the efficacious achievement of the objects and purposes of the Act. It is not for the court to examine the merits or demerits of a policy laid down by regulation-making body, because its scrutiny has to be limited to the question as to whether the impugned regulations fall within the scope of the regulation-making power conferred on the delegate by the statute. Any drawbacks in the policy incorporated in a rule or regulation will not render it ultra vires, and the court cannot strike it down on the ground that, in its opinion, it is not a wise or prudent policy, but is even a foolish one, and that it will not really serve to effectuate the purposes of the Act. The constitutionality of the regulations has to be adjudged only by a threefold test, namely, 1. Whether the provisions of such regulations fall within the scope and ambit of the power conferred by the statute on the delegate. 2. Whether the rules, regulations framed by the delegate are to any extent inconsistent with the provisions of the parent enactment. And lastly, 3. Whether they infringe any of the fundamental rights or other restrictions or limitations imposed by the Constitution. In Hukam Chand v. Union of India AIR 1972 SC 2427, it was observed that unlike sovereign legislature, which has power to enact laws with retrospective operation, authority vested with the power of making subordinate legislation has to act within the limits of its power and cannot transgress the same. The initial difference between subordinate legislation and the statute laws lies in the fact that a subordinate law-making body is bound by the terms of its delegated or derived authority, and that court of law, as a general rule, will not give effect to the rules thus made, unless satisfied that all the conditions precedent to the validity of the rules have been fulfilled. Q. 16a. What do you mean by excessive delegation? Does the court disapprove the practice of excessive delegation? Ans. It is well settled that essential and primary legislative functions must be performed by legislative itself, and they cannot be delegated to the executive. It is now settled by the majority judgment in the Delhi Laws Act case and a number of later cases that there is a limit beyond which delegation may not go. The limit is that essential legislative powers of legislation cannot be delegated. If the legislature delegates the essential legislative function, it is in excess of what it should do. It consists in delegating the power to determine or choose the legislative policy and of formally enacting the policy into a binding rule of conduct. In this case, the latter part of Section 2 of Part C states, Laws, Act, 1950, which provided that provision may be made in any enactment so extended for the repeal or amendment of any corresponding law which is for the time being applicable to the Part C state, was declared ultra vires, because the law to repeal or abrogate existing law is an essential legislative function, which cannot be delegated to the executive. In St. John's Teachers Training Institute v. Regional Director, National Council for Teacher Education, AIR 2003 SC 1533, it was observed that the question whether any particular legislation suffers from excessive delegation has to be decided having regard to the subject matter, the scheme, the provisions of the statutes including its preamble and the facts and circumstances in the background of which the statute is enacted. It is also well settled that in considering the vires of subordinate legislation one should start with the presumption that it is intra vires, and if it is open to two constructions, one of which would make it valid and other invalid, the courts must adopt that construction which makes it valid, and the legislation can also be read down to avoid its being declared ultra vires. In Quarry Owners Association v. State of Bihar AIR 2000 SC 2870, it was observed that in order to adjudicate whether any delegation of power is unbridled or excessive, the historical background of similar provisions which preceded the impugned provision should be kept in mind, as it is also a relevant consideration. Under the earlier Act of 1948, the extraction of minor minerals was left to be regulated by the provincial governments. That pattern was approved by Parliament in the new Act. That being so, even on consideration of historical background, there is nothing wrong to delegate to the state government power to fix rate of royalty dead rent for the minor minerals. In Registrar of Cooperative Societies v. K. Kunjabamu, AIR 1980 SC 350, Supreme Court reiterated that the power to legislate carries within the power to delegate, but excessive delegation may amount to abdication, and delegation unlimited may invite despotism uninhibited. Therefore, the principle is that the legislature cannot delegate its legislative function. Legislature must be laying down policy and principle, and delegate it may to fill in detail and carry out policy. Moreover, similar principles were laid down by the Supreme Court in Gwalior Rayon Mills MFG Limited v. Ast. Commissioner of Sales Tax and other, AIR 1974 SC 1660, and Avinder Singh v. State of Punjab, AIR 1979 SC 321, in Jyoti Prasad v. Administrator for the Union Territory of Delhi and others, AIR 1961 SC 1602, the Supreme Court held so long as the legislature indicates in the operative provisions of the statute with certainty the policy and purpose of the enactment, the mere fact that legislation is skeleton or the fact that a discretion is left to those entrusted with administering the law, affords no basis either for the contention that there has been an excessive delegation of legislative power as to amount to an abdication of its function, or that the discretion vested is internalized and unguided as to amount to a carte balance to discriminate. Q. 16b. What are the powers which cannot be delegated by the legislature to the executive? Ans. There are certain powers which cannot be delegated to the executive, for such delegation would arm the executive with such powers as would be contrary to democratic tradition and fundamental constitution principles. As a matter of public policy, restrictions are imposed upon the legislature against delegation of powers in following matters. 1. Penal laws under delegated authority. No rule or regulation should be made with a view to declare an act as an offense and make it punishable. If it is to be done, it should be expressly laid down in the parent act. The limits of such delegation should also be clearly provided. In absence of such delineation, the Supreme Court would turn down the law as a case of excessive delegation. 2. Retrospective effects. The executive should not be empowered to make rules to the retrospective effect, since it is purely legislative act. If it is all required under any circumstance, it should have been clearly provided in the Act and the delegated authority should have been clearly mentioned in the Act. No rule should operate from any date prior to the date of commencement of the Act, under which they are framed. 3. Substantive power. To oust the jurisdiction of courts. The range of jurisdiction of the courts and the administration of justice are matters of purely legislative character. It is for the legislature to deal with such matters. No administrative body should have power in delegated capacity to make any change in the jurisdiction of any court of law. 4. Monetary and financial matters. The matters relating to money should be exclusively dealt with by the representatives of people, i.e., Lok Sabha. The Committee on Subordinate Legislation disapproved the practice of empowering the executive to frame rules for granting allowances and prescribing the conditions under which allowances could be claimed. If the executive is to be given such a rule-making power, the rules should not operate before they are approved by the affirmative procedure in the House. 5. Taxation. Under Article 265, it is laid down that no tax shall be levied or collected except by authority of law. Here the term law means statute law, that is an act of the legislature. According to a Travancore High Court judgment in 1953, no tax can be levied either by executive action or by the resolution of House. Statutory rules cannot introduce taxes. 6. Compensation. The principles on which and the manner in which compensation is to be determined in case of compulsory acquisition or requisition by state should be in accordance with law. Although, now after XIVTH amendment, the question of amount of compensation has become non-judicial, yet the principle and manner on which compensation is to be awarded are matters of essential legislative function, which are primarily legislative concerns. The legislature should not delegate such functions to the executive. Executive should not be empowered to exercise any discretion in such cases, because that would arm the executive with extraordinary powers, making it dominant one. Q. 17. What do you understand by doctrine of delegatus non potest delegare? Ans. The doctrine means that a delegate cannot further delegate its powers to any other agency, i.e., one agent cannot lawfully appoint another to perform the duties of agency. The doctrine is a necessary corollary of the doctrine of separation of powers, i.e., one organ of the government cannot encroach upon the powers of another. Therefore, legislative powers cannot be delegated. However, in Delhi Laws Act, the Supreme Court observed that Indian Parliament was never considered an agent of anybody, and so the doctrine delegatus non potest delegare has no application. The doctrine of separation of powers, as applied in the America against excessive delegation, cannot be applied in the same way in India. In Union of India v. K. Roy Ayer 1968 SC 850, it was observed that the maxim delegatus non potest delegare deals with the extent to which a statutory authority may permit another to exercise a discretion entrusted by the statute to itself. It is true that delegation in its general sense does not imply a parting with statutory powers by the authority which grants the delegation, but points rather to the conferring of an authority to do things which otherwise that administrative authority would have to do for itself. If, however, the administrative authority named in the statute has and retains in its hands general control over the activities of the person to whom it has entrusted in part the exercise of its statutory power, and the control exercised by the administrative authority is of a substantial degree, there is in the eye of law no delegation at all, and the maxim delegates non potest delegare does not apply. In other words, if a statutory authority empowers a delegate to undertake preparatory work and to take an initial decision in matters entrusted to it but retains in its own hands the power to approve or disapprove the decision after it has been taken, the decision will be held to have been validly made if the degree of control maintained by the authority is close enough for the decision to be regarded as the authority's own. It is now almost settled that the legislature can delegate its powers of lawmaking after indicating the policy. Therefore, the maxim delegatus non potest delegare, which means that a delegate cannot further delegate, is not attracted in case of delegation by the legislature, i.e. delegated legislation, but certainly applies in case of subdelegation, i.e. where the rule-making authority delegates to itself or to some other subordinate authority a further power to issue rules. The maxim was originally invoked in the context of delegation of judicial power, and implied that in the entire process of adjudication a judge must act personally, except in so far as principle behind the maxim is that a discretion conferred by the statute on an authority must be exercised by the authority alone unless contrary intention appears from the language, scope or object of the statute. However, keeping in view the imperatives of the modern administration, the courts are slow in applying the maxim when there is question of exercise of administrative discretionary powers. Sahani Silk Mills v. ESI Coppin. 1994, 5 SCC 346. Q18. How is delegated legislation controlled? Discuss the judicial control of delegated legislation. Ans. Control of delegated legislation in almost all countries in the world. Technique of delegated legislation is resorted to, and some legislative powers have been delegated to executives by legislator. The practice of delegation of legislative power to the administrative authorities is now accepted as settled one, because it has proved the only efficient means to meet the exigencies of various situations which the legislature has failed to face properly. But as the quoted proverb goes, power corrupts. The executive, having been armed with double powers, i.e. executive as well as rule-making powers, may become arbitrary and abuse the powers so given, without any fear of check or control. In order to avoid the apprehension of its being arbitrary, it is very necessary that the exercise of delegated legislative powers should be subjected to judicial scrutiny and parliamentary control. This basic problem in the area of delegated legislation is that of devising suitable controls and safeguards so that advantage of this technique may be available, while the dangers and risks of abuse inherent in it may be minimized. The controls of delegated legislation operate at two levels. First, at the point of delegation of power by legislature. The question here is, how much power should the legislature be permitted to delegate? Second, at the point of exercise of delegated power by administration. The question here being subject to what restraints and safeguards should the delegate function in exercising the delegated powers? It is the control at the second delegating legislation that is more important. The control mechanism of delegated legislation comprises of parliamentary control, procedural control, consultation, publication, etc., and judicial control. The main thrust of such control is to ensure that the limits of delegation are precisely defined, the delegated power is properly exercised, and the delegated legislation is adequately published. Q19. Discuss the judicial control of delegated legislation in India. Ans. Judicial review of legislation has always been an essential feature of Indian constitution law. The delegated legislation also does not go beyond judicial review by Supreme Court and High Courts. Judicial review upholds the rule of law. Judicial review tend to be more effective because the courts do not merely recommend but can strike down a rule if it is ultra vires the enabling act or the constitution. Judicial review cannot be foreclosed by any manner. Courts can check the validity or otherwise of delegated legislation mainly by applying following tests. I. Substantive ultra vires. 2. Procedural ultra vires. Substantive ultra vires. When a subordinate legislation goes beyond what the delegate is authorized to enact, It is known as substantive ultra vires. Substantive ultra vires means that the delegated legislation goes beyond the scope of the authority conferred on it by the parent statute or by the Constitution. The court will upset subordinate legislation unlike an act of the Parliament, where it contains provisions not authorized by the statute, or where it has exceeded the limits laid down in the parent statute. The administrative authorities are required to act within the limits laid down in the statute. It is the duty of the court to construe the statute and find out whether the powers have been exercised properly. In Sri Sitaram Sugar Co. Limited, MS.V. Union of India, Air 1990 SC 1277, it was observed that power delegated by statute is limited by its terms and subordinate to its objects. The delegate must act in good faith, reasonably, intra vires the power granted, and on relevant consideration of material facts. All his decisions, whether characterized as legislative or administrative or quasi-judicial, must be in harmony with the Constitution and other laws of the land. They must be reasonably related to the purposes of the enabling legislation. If they are manifestly unjust or oppressive, or outrageous or directed to an unauthorized end or do not tend in some degree to the accomplishment of the objects of delegation, courts might well say, Parliament never intended to give authority to make such rules, they are unreasonable and ultra vires. The doctrine of judicial review implies that the repository of power acts within the bounds of the power delegated, and he does not abuse his power. He must act reasonably and in good faith. It is not only sufficient that an instrument is intra vires the parent act, but it must also be consistent with the constitutional principles. In Dwarka Nath v. Municipal Court, AIR 1971 SC 1844, the Supreme Court held Rule 32 framed under Prevention of Food Adulteration Act 1954 as ultra vires of the Act being in excess of the power conferred. The Act authorized the government for restricting the packing and labeling of any food article with a view to preventing the public from being misled as to quantity and quality of the article. Rule 32 provided that there shall be specified on every label name and business address of the manufacturer. The court accepted the contention that the requirement of address under Rule 32 is beyond the power of enabling Act which restricted to quantity and quality only. In the same manner in Ibrahim v. Regional Transport Authority, AIR 1953 SC 79, the court declared the rules framed by the administrative authority for fixing sites for the bus stand as invalid, being in excess of the power conferred by enabling Act which authorized the agency to make rules for the control of transport vehicles. In State of Karnataka v. Vanesh Kamath, AIR 1983 SC 550, court struck down the Rule 5(2) as being inconsistent with the Enabling Act. This rule provided that even though a person has passed the test for driving heavy motor vehicles, he cannot obtain a license unless he had already possessed a license for and has 2 years' experience for driving medium motor vehicle. This rule was found to be in direct conflict with Section 7(7)(a) of the Enabling Motor Vehicles Act 1939, which had provided that a person who passes the test in driving a heavy vehicle is to be deemed also to have passed the test in driving any medium vehicle. In Income Tax Officer v. M.C. Ponus AIR 1970 SC 385, it was observed that the Parliament can delegate its legislative power within the recognized limits. Where any person or authority to which such powers have been delegated by the legislature makes any rule or regulation, it may or may not be possible to make the same so as to give retrospective operation. It will depend on the language employed in the statutory provision, which may in express terms or by necessary implication empower the authority concerned to make a rule or regulation with retrospective effect. But where no such language is to be found, it has been held by the courts that the person or authority exercising subordinate legislative functions cannot make a rule, regulation or bylaw which can operate with retrospective effect. Procedural ultra vires when a subordinate legislation fails to comply with certain procedural requirements prescribed by the parent act or by the general law, it is known as procedural ultra vires. While framing rules, bylaws, regulations, etc., the parent act or enabling statute may require the delegate to observe a prescribed procedure, such as holding of consultations with particular bodies or interests, publication of draft rules or bylaws, laying them before Parliament, etc. It is incumbent on the delegate to comply with these procedural requirements and to exercise the power in the manner indicated by the legislature. Failure to comply with the same may invalidate the rules so framed. But at the same time, it is also to be noted that failure to observe the procedural requirements does not necessarily and always invalidate the rules. This arises out of distinction between mandatory requirements and directory requirements. The following two procedural requirements may now be discussed. 1. Publication. 2. Consultation. 1. Publication. I. Object. It is a fundamental principle of law that ignorance of law is no excuse, ignorantia juris non excusat. But there is also equally established principle of law that the public must have access to the law and they should be given an opportunity to know the law. Publication or making the rules known to the individuals concerned is an essential requirement for validity of delegated legislation. It is so even if the law is silent as to the stipulation of publication. In Harla v. State of Rajasthan, AIR 1951 SC 467, the Supreme Court has held that a law cannot be enforced unless published. The Council by a resolution enacted the Jaipur Opium Act, which was never published in any form. One Harla was prosecuted for the contravention of this law. The court held that publication of some sort is essential, as it would be against natural justice to punish the subjects under a law of which they had no knowledge and of which they could not, even with the exercise of reasonable diligence, have acquired any knowledge. However, the court left it vague as to what channels of publication were to be adopted. 2. Necessity of publication. From the point of view of the individual, it is unfair to publish the rules in any obscure publication. First, publication in the required mode creates certainty in the mind of the individual that rules have been duly made, and this enhances faith in the legal system. Second, it enables him to have easy accessibility to the rules. Where publication in Gazette is held to be merely directory, two results would follow. 1. In the absence of publication at the proper place, delegated legislation cannot be enforced against a person who does not have actual notice or knowledge of rules unless it can be shown that adequate steps were taken to bring the rules home to the affected people. 2. The rule-making authority will be bound by rules, and even a person who did not know of the rules earlier but comes to know of them later can take advantage of them even though they have not been published in official gazette, but in some other way. 2. Consultation. The term consult implies a conference of two or more persons or an impact of two or more minds in respect of a topic in order to enable them to evolve a correct or, at least, satisfactory solution of a problem. An important measure to check and control the exercise of legislative power by the executive is the technique of consultation through which affected interests may participate in the rule-making process. This modus operandi is regarded as a valuable safeguard against misuse of legislative power by the executive authorities. This process of exchange of ideas is beneficial to both, to the affected interests itself insofar as they have an opportunity to impress on the authority their point of view, and to the rule-making authority insofar as it can gather necessary information regarding the issues involved and thus be in a better position to appreciate a particular situation. The administration is not always the repository of ultimate wisdom. It learns from the suggestions made by outsiders and often benefits from that advice. Q20. Discuss legislative control over delegated legislation. Ans. It is not only the right of the legislature, but also its duty, as principal, to see how its agent, executive, carries out the agency entrusted to it. Hence, parliamentary control over delegated legislation should be a living continuity as a constitutional necessity. The fact is that due to the broad delegation of powers and generalized standard of control also being broad, the judicial control has shrunk, raising the desirability and necessity of parliamentary control. Legislative control reinforces democracy by having delegated legislation reviewed by people's representatives. Thus, the underlying object of parliamentary control is to keep watch over the rulemaking authorities and also to provide an opportunity to criticize them if there is abuse of power on their part. Legislative control can be effectively exercised by I. Laying on table and 2. Scrutiny committee. I. Laying on table. The Parliament exercises a direct special control over the delegated legislation through the techniques of laying on the table of the House rules and regulations framed by administration. In India, there is no general obligation on the administration to lay the rules before the Houses. The consequences of non-compliance with the laying provision depend on whether the provisions in the Enabling Act are mandatory or directory. The laying procedure is provided with a view to enabling the legislature to supervise over the exercise of delegated legislation. In reality, however, even in spite of such laying requirement, the legislative control tends to become a fiction. Members have so many other important, urgent matters to deal with that they hardly find time to go into the question of delegated legislation. The very reasons which cause the growth of delegated legislation also account for legislative control becoming unreal. The Committee on Subordinate Legislation, with a view to bring uniformity in the laying procedure, made the following recommendations. That, in future, the acts containing provisions for making rules, etc., shall lay down that such rules shall be laid on the table as soon as possible. 2. That all rules shall be laid on the table for a uniform and total period of 30 days before the date of their publication. The committee, however, accepted an alternative formula suggested by the government in which the government, instead of agreeing to lay the rules before Parliament prior to their coming into force, proposed to lay them after their coming into force, making them subject to such modifications as might be made by Parliament. There are several types of laying. 1. Laying without further provision for control. Here the Parent Act merely provides that the rules shall be laid before Parliament. They become operative from the date they are laid before the Houses and in exceptional cases, even before they are so laid. 2. Laying with deferred operation. The requirement of laying is linked with postponement of operation of the rules and thus Parliament gets more control. 3. Laying with immediate effect, but subject to annulment. Here the rules come into force when laid before Parliament, but cease to be in operation if disapproved by it within a specified period. 4. Laying in draft but subject to resolution that no further proceedings be taken. This is also a negative resolution procedure. Here draft of statutory rules are required to be laid before Parliament, but the Parent Act provides that the rules should not be made effective until a particular period has expired. 5. Laying in draft and requiring affirmative resolution. This belongs to the realm of positive resolution and provides a stringent parliamentary supervision over delegated legislation unlike the negative resolution procedure. The draft rules do not become effective until an affirmative resolution approving the same has been passed by Parliament. 6. Laying with operation deferred until approval given by affirmative resolution. Here the rules are actually made, but they do not come into operation until approved by Parliament. There is virtually no difference between this procedure and a positive resolution procedure. 7. Laying with immediate effect. but requiring affirmative resolution as a condition for continuance. This form of laying is used where prompt operation of delegated legislation is essential, but strict parliamentary supervision is also necessary. According to the Committee on Delegated Legislation, the statutes contain 4 methods of laying. I. Requirement of mere publication of rules in the official gazette. 2. Requirement of such publication and laying on the table. 3. Over and above the aforesaid 2 conditions, some statutes allowed modification by Parliament. And 4. Requirement of laying of rules for a specified period before they are published in the official gazette. 2. Scrutiny committees. As discussed above, laying on the table has not always been held to be mandatory. Even if that requirement is complied with, mere laying of rules before Parliament would not be of much use unless the rules were properly studied and scrutinized. Therefore, with a view to strengthening parliamentary control over delegated legislation, scrutiny committees are established. In India also, there are 2 scrutiny committees. 1. The Lok Sabha Committee on Subordinate Legislation. 2. The Rajya Sabha Committee on Subordinate Legislation. The function of these committees is to scrutinize and report to the respective houses whether the powers to make regulations, rules, sub-rules, bylaw, etc., conferred by the Constitution or delegated by Parliament are being properly exercised within such delegation. The Indian Committee on Subordinate Legislation has made inter alia the following recommendations and suggestions. 1. Power of judicial review should not be taken away or curtailed by rules. 2. A financial levy or tax should not be imposed by rules. 3. Language of rules should be simple and clear and not complicated or ambiguous. 4. Rules should not be given retrospective operation unless the parent act has expressly conferred such a power. 5. Legislative policy must be formulated by the legislature and laid down in the statute, and the power to supply details may be left to the executive and can be worked out through the rules made by the administration. 6. Discriminatory rules should not be framed by administration. 7. Rules should not travel beyond the rule-making power conferred by the Parent Act. 8. There should not be inordinate delay in making of rules by the administration. 9. The rules framed by the administration and required to be laid before the House by the Parent Act should be laid before Parliament as soon as possible, and whenever there is inordinate delay, an explanatory note giving the reasons for such delay should be appended to the rules so laid. 10. The final authority of interpretation of rules should not be with the administration. 11. Sufficient publicity must be given to the statutory rules and orders. Q. 21. What do you understand by natural justice? Discuss its scope. Ans. Natural justice. Natural justice is an important concept in administrative law. Term natural justice has signified certain fundamental rules of judicial procedure. It is also known as substantial justice, fundamental justice. It is in fact a humanizing principle intended to invest law with fairness, to secure justice, and to prevent miscarriage of justice. In Canara Bank v. Debasi's Das, AIR 2003 SC 2041 it was observed that natural justice is another name for common sense justice. Rules of natural justice are not codified canons, but they are principles ingrained into the conscience of man. Natural justice is the administration of justice in a common sense liberal way. Justice is based substantially on natural ideals and human values. The administration of justice is to be freed from the narrow and restricted considerations, which are usually associated with a formulated law involving linguistic technicalities and grammatical niceties. It is the substance of justice which has to determine its form. Whenever legal justice fails to achieve this solemn purpose, natural justice is called in aid of legal justice. Natural justice relieves legal justice from unnecessary technicality, grammatical pedantry, or logical prevarication. It supplies the omission of a formulated law. Supreme Court in the case of Keshav Mills Co. Limited v. Union of India, 1973, 1 SCC 380, AIR 1973 SC 389 has observed that the second question, however, as to what are the principles of natural justice that should regulate an administrative act or order is a much more difficult one to answer. We do not think it either feasible or even desirable to lay down any fixed or rigorous yardstick in this manner. The concept of natural justice cannot be put into a straitjacket. The only essential point that has to be kept in mind in all cases is that the person concerned should have a reasonable opportunity of presenting his case, and that the administrative authority concerned should act fairly, impartially, and reasonably. Where administrative officers are concerned, the duty is not so much to act judicially as to act fairly. Na S. Dasvi, Union of India AIR 1987 SC 593. It was observed that rules of natural justice are not rigid rules, they are flexible, and their application depends upon the setting and the background of statutory provision, nature of the right which may be effected, and the consequences which may entail its application depends upon the facts and circumstances of each case. These principles do not apply to all cases and situations. Applications of these unmodified rules are often excluded by express provision or by implication. In Union of India v. J.N. Sinha AIR 1971 SC 40, it was observed that rules of natural justice are not embodied rules, nor can they be elevated to the position of fundamental rights. Their aim is to secure justice or to prevent miscarriage of justice. These rules can operate only in areas not covered by any law validly made. They do not supplant the law but supplement it. If a statutory provision can be read consistently with the principles of natural justice, the courts should do so. But if a statutory provision either specifically or by necessary implication excludes the application of any rules of natural justice, then the court cannot ignore the mandate of the legislature or the statutory authority and read into the concerned provision the principles of natural justice. Whether the exercise of a power conferred should be made in accordance with any of the principles of natural justice or not depends upon the express words of the provision conferring the power, the nature of the power conferred, the purpose for which it is conferred, and the effect of the exercise of that power. Thus, in simple words, the rules of natural justice can be summarized in the following manner. Firstly, it signifies that one cannot be a judge in his own cause. 2. One who hears should decide. 3. Opportunity to the parties of being heard, any producing evidence in support of their allegation. 4. Right to cross-examination. The broad principles of natural justice are as follows. A quasi-judicial authority cannot make any decision adverse to any party without giving him an effective opportunity of meeting any allegation against him. 2. That every person whose civil right is affected must have a reasonable notice of the case he has to meet. 3. That he must have a reasonable opportunity of being heard in his defense. 4. That he must have the opportunity of adducing all relevant evidence on which he relies, the evidence of the opponent should be taken in his presence, and that he must have the opportunity of cross-examining the witness examined or relied upon by the opponent, and documents which are necessary for the purpose of an effective exercise of the foregoing rights should not be withheld from such person. In the case of Board of Mining Examination v. Ramji, AIR 1977 SC 967, Supreme Court has disfavored the extension of natural justice rule to administrative fields. Krishna Iyer J. observed, Natural justice is no unruly horse, no lurking landmine, nor a judicial cure to all. If fairness is shown by the decision maker to the man proceeded against, the form, features and the fundamentals of such essential processional propriety being conditioned by the facts and circumstances of each situation, no breach of natural justice can be complained of. A natural expansion of natural justice, without reference to the administrative realities and other factors of a given case, can be exasperating. The Supreme Court in Maneka Gandhi v. Union of India, 1978, 1 SCC 248, equated the rules of natural justice to the Americans' due process and emphasized its application in administrative procedures. The court felt the necessity of spelling out fair procedure in all these cases where the legislature enacts a law which may affect the rights of an individual. Q. 22. What do you understand by rule against bias? Discuss the application of rule in Indian law. Ans. Rule against bias. One of the principles of natural justice is the rule against bias, which is described as nemo judex in causa sua or nemo debet esse judex in propria causa sua, that is, no man shall be a judge in his own cause. Coke used the form aliquis non debet esse judex in propria causa quae non potest esse judex at pars, that is, no man ought to be a judge in his own case, because he cannot act as judge and at the same time be a party. The form nemo potest esse simul acta et judex, that is, no one can be at once suitor and judge, is also at times used. So rule against bias signifies that no man shall be a judge in his own cause, or in other words a judge is disqualified from hearing a case in which has pecuniary or other interest. Judicial officer should be impartial and neutral and must be free from bias. He is supposed to be indifferent to the parties to the controversy. He cannot act as judge of a cause in which he himself has some interest, either pecuniary or otherwise, as it affords the strongest proof against neutrality. In Ashok Kumar Yadav v. State of Haryana, AIR 1987 SC 454, it was observed. It is one of the fundamental principles of our jurisprudence that no man can be a judge in his own cause, and that if there is a reasonable likelihood of bias, it is in accordance with natural justice and common sense that the justice likely to be so biased should be incapacitated from sitting. The question is not whether the judge is actually biased or in fact decides partially, but whether there is a real likelihood of bias. What is objectionable in such a case is not that the decision is actually tainted with bias, but that the circumstances are such as to create a reasonable apprehension in the mind of others that there is a likelihood of bias affecting the decision. The basic principle underlying this rule is that justice must not only be done but must also appear to be done. It is also important to note that this rule is not confined to cases where judicial power stricto sensu is exercised. It is appropriately extended to all cases where an independent mind has to be applied to arrive at a fair and just decision between the rival claims of parties. Justice is not the function of the courts alone, it is also the duty of all those who are expected to decide fairly between contending parties. The strict standards applied to authorities exercising judicial power are being increasingly applied to administrative bodies, for it is vital to the maintenance of the rule of law in a welfare state where the jurisdiction of administrative bodies is increasing at a rapid pace, that the instrumentalities of the state should discharge their functions in a fair and just manner. Types of bias. Bias is of three types. I. Pecuniary bias. 2. Personal bias, and 3. Official bias or bias as to subject matter. I. Pecuniary bias. It is well settled that as regards pecuniary interest, the least pecuniary interest in the subject matter of the litigation will disqualify any person from acting as a judge. Griffith and Street rightly state that a pecuniary interest, however slight, will disqualify, even though it is not proved that the decision is in any way affected. In Dimes v. Grand Junction Canal, 1852, 8 Co. Rep. 113b, 77 All ER 646 is considered to be the classic example of the application of the rule against pecuniary interest. In this case, the Vice-Chancellor decreed the suits and the appeals against those decrees were filed in the court of Lord Chancellor Cottenham. He dismissed the appeals and decrees were confirmed in favor of a canal company in which he was a substantial shareholder. The House of Lords agreed with the Vice-Chancellor and affirmed the decrees on merits. In fact, Lord Cottenham's decision was not in any way affected by his interest as a shareholder, and yet the House of Lords quashed the decision of Lord Cottenham. Lord Campbell observed, "No one can suppose that Lord Cottenham could be, in the remotest degree, influenced by the interest that he had in this concern, but my lords, it is of the last importance that the maxim, that no one is to be a judge in his own cause, should be held sacred. And it will have a most salutary influence on inferior tribunals when it is known that this High Court of last resort, in a case in which the Lord Chancellor of England had an interest, considered that his decree was on that account a decree not according to law, and was set aside." In Mohapatra and Kovi, State of Orissa, 1984, 4 SCC 103, 112, AIR 1984 SC 1572, 1576, some of the members of the committee set up for selecting books for educational institutions were themselves authors whose books were to be considered for selection. The Supreme Court held that the possibility of bias could not be ruled out. Maiden, J. observed, "It is not the actual bias in favor of the author member that is material, but the possibility of such bias." 2. Personal bias. The judge may be a friend of the party, or related to him, or have some business or professional relationship with him, or may even have personal animosity or hostility against him. In Mineral Development Limited B, State of Bihar, AIR 1960 SC 468, the Revenue Minister had cancelled the petitioner's license for the lease of certain land. It was found that there was political rivalry between petitioner and the minister. In Manak Lal v. Prem Chand, AIR 1957 SC 125, in order to decide a complaint for professional misconduct filed by Prem Chand against Manak Lal, an advocate of Rajasthan High Court, the High Court appointed a tribunal consisting of a senior advocate, one Advocate General of Rajasthan, as chairman. The tribunal's decision was challenged on ground of a personal bias arising from the fact that chairman had represented Prem Chand in an earlier case. The court refused to quash the action on the basis of real likelihood of bias, as the chairman had no personal contact with his client and did not remember that he appeared on his behalf. However, the high professional standards led the court to quash action on ground that justice should not only be done but must appear to have been done. Actual proof of prejudice was not necessary. Reasonable ground for assuming the possibility of bias was sufficient. In State of UP v. Mohd, No. AIR 1958 SC 86, a departmental inquiry was held against A by B. As one of the witnesses against A turned hostile, B left the inquiry, gave evidence against A, resumed to complete the inquiry and passed an order of dismissal. The Supreme Court held that the rules of natural justice were completely discarded and all canons of fair play were grievously violated by B. Similarly, in Ratan Lal v. Managing Committee, 1993, 4 SCC 10, AIR 1993 SC 2155, X was a witness as well as one of the three members of an inquiry committee against A. At the inquiry, A was found guilty and was dismissed. Setting aside dismissal and following Mohd, No. The Supreme Court held that the proceedings were vitiated because of prejudice of one of the members of the committee. 3. Official bias. The third types of bias is official bias or bias as to the subject matter. This may arise when the judge has a general interest in the subject matter. Those cases fall within this category where the deciding officer is directly or otherwise involved in the subject matter of the case. Here again, mere involvement would not vitiate administrative action unless there is a real likelihood of bias, i.e., unless the adjudication has intimately identified himself with the issues. In Gullapalli Nageshwar Rao v. APSRTC, Gullapalli I, AIR 1959 SC 308, the petitioners were carrying on motor transport business. The Andhra State Transport Undertaking published a scheme for nationalization of motor transport in the state and invited objections. The objections filed by the petitioners were received and heard by the Secretary, and thereafter the Chief Minister approved the scheme. The Supreme Court upheld the contention of the petitioners that the official who heard the objections was in substance one of the parties to the dispute, and hence the principles of natural justice were violated. Q23. Discuss rule of fair hearing. Or explain meaning and scope of Audi Alteram Partem. Ans. Rule of fair hearing. Second important principle of natural justice is Audi Alteram Partem, i.e. rule of fair hearing, which implies that each party before their rights or liabilities are adjudicated upon must be given opportunity of being heard. In Union of India v. W. and Chada AIR 1993 SC 1082, it was observed that the rule of Audi Alteram Partem is not attracted unless the impugned order is shown to have deprived a person of his liberty or his property. The rule of Audi Alteram Partem is a rule of justice, and its application is excluded where the rule will itself lead to injustice. There is exclusion of the application of Audi Alteram Partem rule to cases where nothing unfair can be inferred by not affording an opportunity to present and meet a case. This rule cannot be applied to defeat the ends of justice or to make the law lifeless, absurd, stultifying, and self-defeating, or plainly contrary to the common sense of the situation, and this rule may be jettisoned in very exceptional circumstances where compulsive necessity so demands. There are certain exceptional circumstances and situations wherein the application of the rule of Audi Alteram Partem is not attracted. It is no doubt true that the fact that a decision, whether a prima facie case has or has not been made out, is not by itself determinative of the exclusion of hearing, but the consideration that the decision was purely an administrative one and a full-fledged enquiry follows is a relevant and indeed a significant factor in deciding whether at that stage there ought to be hearing, which the statute did not expressly grant. Generally, this maximum includes two elements: I. Notice, and 2. Hearing. I. Notice. Before any action is taken, the affected party must be given a notice to show cause against the proposed action and seek his explanation. It is a sine qua non of the right of fair hearing. Any order passed without giving notice is against the principles of natural justice and is void ab initio. Unless a person knows the formulation of subjects and issues involved in the case, he cannot defend himself. A notice must be adequate and contain 1. Time, place and nature of hearing. 2. Legal authority under which hearing is to be held. 3. Statement of specific charges, or grounds, and proposed action, or grounds, which the person has to meet. However, the requirement of notice will not be insisted upon as a mere technical formality, when the concerned party clearly knows the case against him, and is not thereby prejudiced in any manner in putting up an effective defense. Therefore, in Keshav Mills Covey, Union of India, AIR 1973 SC 389, the Supreme Court did not quash the order of the government taking over the mill for a period of 5 years on the technical ground that the appellants were not issued notice before this action was taken, because, at an earlier stage, a full-scale hearing had already been given, and there was nothing more which the appellant wanted to know. 2. hearing. The second requirement of Audi Alteram Partem maxim is that the person concerned must be given an opportunity of being heard before any adverse action is taken against him. In state of Orissa v. Binapani Day AIR 1967 SC 1269, the petitioner was compulsorily retired from service on the ground that she had completed the age of 55 years. No opportunity of hearing was given to her before the impugned order was passed. The Supreme Court set aside the order as it was violative of the principles of natural justice. Again, in Maneka Gandhi v. Union of India, AIR 1978 SC 597, the passport of the petitioner journalist was impounded by the Government of India in public interest. No opportunity was given to the petitioner before taking the impugned action. The Supreme Court held that the order was violative of the principles of natural justice. Although an adjudicating authority must observe the principles of natural justice and must give a reasonable opportunity of being heard to the person against whom the action is sought to be taken. But in England and in America, it is well settled law that in absence of statutory provisions, an administrative authority is not bound to give the person concerned an oral hearing. In India also, the same principle is followed. A person is not entitled to an oral hearing unless the statute confers such a right. In MP Industries v. Union of India AIR 1966 SC 671, Subba Rao, J. observed, "It is no doubt a principle of natural justice that a quasi-judicial tribunal cannot make any decision adverse to a party without giving him an effective opportunity of meeting any relevant allegations against him. But the said opportunity need not necessarily be by personal hearing. It can be by written representation. Whether the said opportunity should be by written representation or by personal hearing depends upon the facts of each case, and ordinarily it is in the discretion of the tribunal." Q24. Whether the doctrine Audi Alteram Partem or right of being heard has got statutory recognition in India? Ans. In India, doctrine of Audi Alteram Partem has been well recognized in different statute book. This principle is no longer a principle of administrative law but has found its place in statute books as the very system of judicial administration is based on fair trial. Many statutes enacted in India contain provisions based on the principle that each party in judicial or quasi-judicial proceedings should get opportunity of being heard before adjudication upon their right or liabilities. In India, under the Income Tax Act, 1961, the right to hearing has been very widely made available. An order prejudicial to assessee cannot be passed by Assistant Commissioner, Appeal, or the Appellate Tribunal without giving him reasonable opportunity to meet the case. Section 254(1) of the said Act again provides, "The Appellate Tribunal may, after giving both the parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit." The proviso of Section 254(2) lays down, provided that an amendment which has the effect of enhancing an assessment or reducing a refund or otherwise increasing the liability of the assessors shall not be made under this subsection unless the Appellate Tribunal has given notice to the assessee a reasonable opportunity of being heard. Thus, the provisions requiring the income tax authorities and the Appellate Tribunal to give reasonable opportunity to show cause or to represent one's view are made whenever the interests of the assessee are affected. Under the Representation of the People's Act, 1951, provisions for hearing are like that under Civil Procedure Code, when an actual suit is tried by the court. The rules regarding the appearance of the opposite party and the production of evidence are same as they are laid down in Civil Procedure Code. Under Section 85 of the Act, the proviso clearly guarantees the opportunity to be heard. Section 85 laid down, if the provisions of Section 81 or Section 82 or Section 107 have not been complied with, the Election Commission shall dismiss the petition, provided that the petition shall not be dismissed without giving the petitioner an opportunity to be heard. Similarly, in criminal trial, in course of trial before pronouncement of judgment, he is entitled to be heard on the evidence which has come on record against him. Section 313 Criminal Procedure Code provides that accused will be given opportunity to explain and answer about those facts, evidence of which has been produced by prosecution. Similarly, U.S. 35(2)(3) of Copyright Act, the Copyright Board is required to give notice and a reasonable opportunity of being heard. Subsec 2 of Section 35 provides, the Copyright Board shall, in respect of every such rule, give notice thereof. Subsec 3 again provides, the Copyright Board shall, after giving such society and the person who lodged the objection a reasonable opportunity of being heard, and after making such further enquiry as may be prescribed. Thus, if we look in the principal statutes of India, which provide for tribunals, each of them contains provisions for an opportunity of being heard. Where the right has not been conceded in express words, it should be assumed as an essential requirement of the fair procedure. Under the Constitution itself, there are provisions which give an opportunity to show cause while any action is taken against a government servant in connection with his dismissal or reduction in rank. Under Article 331 of the Constitution, Clause 2 clearly provides, no such person as aforesaid shall be dismissed or removed or reduced in rank until he has been given a reasonable opportunity of showing cause against the action proposed to be taken in regard to him. Provided that this clause shall not apply: A. Where a person is dismissed or removed or reduced in rank on the ground of misconduct which has led to his conviction on a criminal charge. B. Where an authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reasons to be recorded by that authority in writing it is not reasonable, practicable to give to that person an opportunity of showing cause, or C. Where the President or Governor, as the case may be, is satisfied that in the interest of the security of the state it is not expedient to give to that person due opportunity. Thus, we find that except under the above three conditions, a reasonable opportunity to be heard has been clearly guaranteed. In India, reasonable opportunity of being heard clause has been given statutory recognition in almost all cases. It was thought to be an essential condition of getting justice. Without it, the true end of judicial hearing will be frustrated. Q. 25. In what cases the rule of Audi Alteram Partem can be excluded? Ans. There are certain conditions in which the rule of Audi Alteram Partem is not applied. These limitations on the right to be heard are either based on statutory provisions or on public policy. They are excluded on the grounds of national security, public policy, and expediency. Such conditions can be classified in the following manner. 1. Where the functions of the authority concerned are held to be policy-oriented. 2. Where the authority concerned is vested with wide discretion. 3. Where the legislation expresses the requirement of notice and hearing for some purposes but imposes no procedural requirement for other purposes. 4. Where the imposition of compliance with the rule, i.e., to disclose relevant information to the party affected would be prejudicial to the public interest. 5. Where the obligation to give notice and opportunity to be heard would obstruct the taking of prompt action, especially action of a prevention and remedial nature. 6. Where for any reasons, it becomes impracticable to give prior notice or opportunity of hearing. 7. Where the matter in issue or the monetary value of the interests at stake is too insignificant. 8. Where the power exercised is disciplinary. Q. 26. What do you understand by concept of passing reason or speaking order? What is the object of it? Ans. A speaking order means which is self-explanatory and is speaking for itself. It precisely means an order which lays down the reasons and grounds on the basis of which it was passed. Importance of recording of reasons. The reasoned decision facilitates the exercise of appellate or revisional powers, acts as deterrent against arbitrary exercise of powers, and gives satisfaction to the party against whom order is made. If administrative authority is allowed to keep its errors off the record by not writing reasons, the whole concept of judicial review would be meaningless. In order to maintain and uphold rule of law, it is necessary that in all administrative and quasi-judicial actions, the requirement of a reasoned decision must be implied unless expressly excluded. Object: the condition to record reasons introduces clarity and excludes arbitrariness and satisfies the party concerned against whom the order is passed. Today, the old police state has become a welfare state. The governmental functions have increased, administrative tribunals and other executive authorities have come to stay, and they are armed with wide discretionary powers, and there are all possibilities of abuse of power by them. To provide a safeguard against the arbitrary exercise of powers by these authorities, the condition of recording reasons is imposed on them. If the statute requires recording of reasons, then it is the statutory requirement and, therefore, there is no scope for further inquiry. But even when the statute does not impose such an obligation, it is necessary for the quasi-judicial authority to record reasons, as it is the only visible safeguard against possible injustice and arbitrariness and affords protection to the person adversely affected. Reasons are the links between the materials on which certain conclusions are based and the actual conclusions. They disclose how the mind is applied to the subject matter for a decision, whether it is purely administrative or quasi-judicial. They should reveal a rational nexus between the facts considered and the conclusion reached. The courts insist upon disclosure of reasons in support of the order on 3 grounds. 1. The party aggrieved has the opportunity to demonstrate before the appellate or revisional court that the reasons which persuaded the authority to reject his case were erroneous. 2. The obligation to record reasons operates as a deterrent against possible arbitrary action by executive authority invested with judicial power. And 3. It gives satisfaction to the party against whom the order is made. The power to refuse to disclose reasons in support of the order is exceptional in nature, and it ought to be exercised fairly, sparingly, and only when fully justified by the exigencies of an uncommon situation. Q27. What is post-decisional hearing? Why was it propounded? Ans. The idea of post-decisional hearing has been developed to maintain a balance between administrative efficiency and fairness to the individual. This technique was developed by Supreme Court in Maneka Gandhi v. Union of India, AIR 1978 SC 597. In this case, the facts were that the passport dated 1st June 1976 of the petitioner, a journalist, was impounded in public interest by an order dated 2nd July 1977, and the government having declined to furnish to her the reasons for its decision, she filed a petition before the Supreme Court under Article 32 challenging the validity of the impoundment order. The government also did not give her any pre-decisional notice and hearing. One of the contentions of the government was that the rule of Audi Alteram Partem must be held to be excluded because it may have frustrated the very purpose of impounding the passport. Rejecting the contention, the Supreme Court held that even though the impoundment of the passport is an administrative action, yet the rule of fair hearing is attracted by necessary implication, and it would not be fair to exclude the application of this cardinal rule on the ground of administrative convenience. However, the court did not outright quash the order and allowed the return of passport because of the special socio-political factors attending the case. On the contrary, the technique of post-decisional hearing was developed in order to balance these factors against the clear requirement of law, justice and fairness. The court stressed that a fair opportunity of being heard following immediately upon the order impounding the passport would satisfy the mandate of natural justice. The same technique of validating void administrative decision by post-decisional hearing was adopted in Swadeshi Cotton Mills v. Union of India, AIR 1981 SC 818. In this case, the court validated the order of the government for taking over the management of this company, which had been passed in violation of Audi Alteram Partem rule and which was found to have been attracted by necessary implication because the government had agreed to give post-decisional hearing. In Shepherd v. Union of India AIR 1988 SC 686, certain banks were ordered to be amalgamated with some nationalized banks. Certain employees of private banks were excluded from employment in the nationalized banks. Thus, their services were terminated without giving them an opportunity of hearing. The Supreme Court rejected the proposal for a post-amalgamation hearing since there was no justification to think of a post-decisional hearing. The court rightly observed, it is common experience that once a decision has been taken, there is a tendency to uphold it, and a representation may not yield any fruitful purpose. In Trehan v. Union of India AIR 1989 SC 568, a circular was issued by a government company, prejudicially altering the terms and conditions of its employees without affording an opportunity of hearing to them. In reply to the said contention, an argument was advanced by the company that after the impugned circular was issued, an opportunity was given to the employees with regard to the alteration made by the circular. In other words, a plea regarding post-decisional hearing was put forward. Negating the contention and following Shepherd case, Supra, the Supreme Court reiterated, in our opinion, the post-decisional opportunity of hearing does not subserve the rules of natural justice. The authority who embarks upon a post-decisional hearing will normally proceed with a closed mind, and there is hardly any chance of getting proper consideration of the representation at such a post-decisional opportunity. Conclusions: a prior hearing may be better than a subsequent hearing, but a subsequent hearing is better than no hearing at all. The approach may be acceptable where the original decision does not cause serious detriment to the person affected, or where there is also a paramount need for prompt action, or where it is impracticable to afford antecedent hearings. In substance, it is the necessity for speed which justifies post-decisional hearing at a later stage. Q. 28. Discuss the effects of non-observance of principles of natural justice. Ans. Effect of non-observance of the rules of natural justice. Rules of natural justice have to be followed as a matter of public policy. The rules of natural justice know of no exclusionary rule dependent on whether it would have made any difference if natural justice had been observed. The non-observance of natural justice is itself prejudice to any man, and proof of prejudice independently of proof of denial of natural justice is unnecessary. S.L. Kapoor v. Jagmohan, AIR SC 136. The question whether failure to observe the rules of natural justice makes the decision void or voidable has arisen in recent years. There is a viewpoint that failure to observe the principles of natural justice amounts to acting ultra vires, and therefore such an action must be void ab initio. On the other hand, we have cases in which decisions, though taken without compliance with the rules of natural justice, were not set aside. The courts are unanimous that a decision rendered in violation of the rule against bias is merely voidable and not void. The aggrieved party may thus waive his right to avoid the decision, as where timely objection is not made even though there is full knowledge of the bias, and the right to object to it. Manak Lal v. Dr. Prem Chand AIR 1957 SC 425. However, there is fundamental disagreement amongst the courts and jurists as to the effect of a breach of the rule of fair hearing on any decision. If hearing is a requirement of the reasonableness of a restriction on a fundamental right, non-compliance with it will render the decision void ab initio. Nawab Khan v. State of Gujarat AIR 1974 SC 1471. Where the requirement is statutory or an implied requirement of law, a decision taken without complying with it would not be void. If a person does not insist, in spite of his awareness, upon his right to be heard or right to cross-examine or the right to engage a lawyer or for disclosure of relevant documents, the actions would not be rendered void if such facilities are not given to him unless such action had resulted in grave injustice. In R. L. Sharma v. Managing Committee, Mr. Hari Ram, Co-ed. H.S. School, AIR 1996 SC 2155, in a departmental enquiry against Principal, one member of Enquiry Committee, who was inimical towards the Principal, appeared as witness against delinquent to prove one of the several charges. Held that the fact that delinquent does not raise specific pleas or objection on this ground before authority granting approval to propose punishment or before appellate authority is immaterial. A plea cannot be allowed to be raised for the first time in writ proceeding unless it goes to the root of the question. In the present case, held that the enquiry is vitiated as the bias, personal, percolates throughout the enquiry proceedings. Thus, in State of Patiala v. S.K. Sharma AIR 1996 SC 1669, it was observed that it would not be correct to say that for any and every violation of a facet of natural justice, an order passed is always null and void. The validity of the order has to be tested on the touchstone of prejudice. The ultimate test is always the same, viz., the test of prejudice or the test of fair hearing. Q. 29. What do you mean by administrative tribunals? Discuss various reasons for growth of tribunals in modern times. Ans. Governmental functions have increased, and even though according to the traditional theory, the function of adjudication of disputes is the exclusive jurisdiction of the ordinary courts of law, in reality, many judicial functions have come to be performed by the executive, e.g. imposition of fine, levy of penalty, confiscation of goods, etc. The traditional theory of laissez-faire has been given up and the old police state has now become a welfare state, and because of this radical change in the philosophy as to the role to be played by the state, its functions have increased. It regulates the industrial relations, exercises control over production, starts many enterprises. The issues arising therefrom are not purely legal issues. It is not possible for the ordinary courts of law to deal with all these socio-economic problems. All the same, it is necessary that such disputes should not be determined in an arbitrary or autocratic manner. Administrative tribunals are, therefore, established to decide various quasi-judicial issues in place or ordinary courts of law. The status of tribunals has been recognized by the Constitution. Article 136 of the Constitution empowers the Supreme Court to grant special leave to appeal from any judgment, decree, determination, sentence or order passed or made by any tribunal in India. Likewise, Article 227 enables every High Court to exercise power of superintendence over all tribunals throughout the territories over which it exercises jurisdiction. By the Constitution, 42 ND Amendment, Act, 1976, Articles 323-A and 323-B have been inserted by which Parliament has been authorized to constitute administrative tribunals for settlement of disputes and adjudication of matters specified therein. In Bharat Bank v. Employees AIR 1950 SC 188, the Supreme Court observed that though tribunals are clad in many of the trappings of a court, and though they exercise quasi-judicial functions, they are not full-fledged courts. Thus, a tribunal is an adjudicating body, which decides controversies between the parties and exercises judicial powers as distinguished from purely administrative functions and thus possesses some of the trappings of a court, but not all. According to Wade, the expression administrative tribunals is misleading for various reasons. Firstly, every tribunal is constituted by an act of parliament and not by government. Secondly, decisions of such tribunals are judicial rather than administrative. A tribunal reaches a finding of fact, applies law to such fact and decides legal question objectively and not on the basis of executive policy. Thirdly, all tribunals do not deal with cases in which government is a party. Some tribunals adjudicate disputes between two private parties, e.g. disputes between landlords and tenants, employers and employees, etc. Finally, such tribunals are independent. Q30. What is the nature of administrative tribunals? State basic characteristics of an administrative tribunal. How an administrative tribunal is distinguished from courts of law? Ans. An administrative tribunal is not a court nor an executive body. It stands somewhere midway. It is, as a matter of fact, offspring of compromise between executive and the judiciary. Professor Wade says they are often called administrative tribunals, but this does not mean that their decisions are necessarily administrative. In the great majority of cases, they are judicial in the sense that the tribunal has to decide facts and apply rule to them impartially, without considering executive policy. Such tribunals in substance are court of law. They are administrative because the reasons for preferring them to the ordinary courts of law are administrative reasons. He further writes, these tribunals, therefore, have the character of courts, but they are deeply enmeshed in the administrative machinery of the state. Their working and structure is an important topic of administrative law. The establishment of the tribunals is under the law. Although the members of the tribunals are appointed by the government, and mostly they are officials, yet they work independently without being influenced by the government. In India, the establishment of these adjudicative bodies is constitutionally recognized. In APHL Conference, Shillong v. W.A. Sangama, AIR 1977 SC 2155, the Supreme Court held that the principal test which must necessarily be present in determining the character of the authority as the tribunal is whether that authority is empowered to exercise any adjudicating power of the state and whether the same has been conferred on it by any statute rule. Tribunals are, thus, administrative bodies set up solely with the idea of discharging quasi-judicial duties. Their determination affects the rights of parties. They, therefore, have been held to be quasi-judicial bodies. The tribunal is generally given the power of a civil court enjoyable under the Code of Civil Procedure in matters of summoning witnesses, compulsory production and discovery of documents, receiving of evidence on oath and on affidavit, issuing commissions, etc. For example, the Railway Rates Tribunal is expressly declared as civil court, and contempt of this tribunal is punishable under sections 172 to 188 of the Penal Code in accordance with the procedure prescribed in sections 195 and 476 of Criminal Procedure Code. The proceeding before the Appellate Tribunal of Income Tax, the Controller of Estate Duty, the Appellate Controller of Estate Duty and others are expressly declared to be judicial proceedings. The following are the characteristics of an administrative tribunal. 1. An administrative tribunal is the creation of a statute and thus, it has a statutory origin. 2. It has some of the trappings of a court, but not all. 3. An administrative tribunal is entrusted with the judicial powers of the state and thus, performs judicial and quasi-judicial functions, as distinguished from pure administrative or executive functions and is bound to act judicially. 4. Even with regard to procedural matters, an administrative tribunal possesses powers of a court, e.g. to summon witnesses, to administer oath, to compel production of documents, etc. 5. An administrative tribunal is not bound by strict rules of evidence and procedure. 6. The decisions of most of the tribunals are in fact judicial rather than administrative inasmuch as they have to record findings of facts objectively and then to apply the law to them without regard to executive policy. 7. Administrative tribunals are independent and they are not subject to any administrative inference. 8. The prerogative writs of certiorari and prohibition are available against the decisions of administrative tribunals. Administrative tribunal distinguished from court. An administrative tribunal is similar to a court in certain aspects. A tribunal possesses some of the trappings of a court, but not all, and therefore, both must be distinguished. 1. A court of law is a part of the traditional judicial system, where judicial powers are derived from the state. On the other hand, an administrative tribunal is an agency created by a statute and invested with judicial powers. Primarily and essentially, it is a part and parcel of the executive branch of the state, exercising executive as well as judicial functions. 2. Whereas ordinary civil courts have judicial power to try all suits of a civil nature, excepting those whose cognizance is either expressly or impliedly barred, tribunals have power to try cases in special matters statutorily conferred. 3. Judges of ordinary courts of law are independent of the executive in respect of their tenure, terms and conditions of service, etc. On the other hand, members of administrative tribunals are entirely in the hands of the government in respect of those matters. 4. A court of law is generally presided over by an officer trained in law, but the president or a member of a tribunal may not be trained as well in law. 5. A court of law is bound by all the rules of evidence and procedure, but an administrative tribunal is not bound by those rules unless the relevant statute imposes such an obligation. 6. A court must decide all the questions objectively on the basis of the evidence and materials produced before it, but an administrative tribunal may decide the questions taking into account the departmental policy or expediency, and in that sense, the decision may be subjective rather than objective. 7. While precedents, principles of res judicata, and estoppel bind a court of law, they do not strictly bind an administrative tribunal. 8. A court of law can decide the views of a legislation, while an administrative tribunal cannot do so.